right. Good morning, ladies and gentlemen. I am Claudia Robinson, and I'm the judge that is presiding over Magistrate Court this morning. I'm going to give you some brief explanations as to what's going to happen, what the purpose of this hearing is for. Good morning, Mr. Afzal. And then we'll briefly get started.
Good morning, Judge.
This hearing this morning, ladies and gentlemen, is for three purposes. The first purpose is to determine probable cause. That is a non-adversarial hearing. Basically, probable cause means that if there was probable cause for the arrest, which means whether there was a reasonable grounds to believe a crime was committed and that you were the person that committed that crime. Also, the purpose of this hearing is to go ahead and set any pretrial release conditions, including bond. So that will be done as well. I remind you, ladies and gentlemen, that you have a right to remain silent under the Fifth Amendment to the United States Constitution. So please do not talk to me about the facts of the case. That is of the utmost importance, because everything in this courtroom is being recorded and it can and will be used against you in the event that you make any admissions or talk about the facts of the case. So please do not talk to me about the facts of the case. So with that being said, we'll go ahead and, actually, you want to do Mr. House's case first? We have
Good morning, John Howes on behalf of Mr. Bain, who's on page 4.
Walter, you pronounce it Bain?
Bain, yes.
Okay.
Judge, we have an agreement with the state with respect to the plea, to a bond on this matter.
Okay, Mr. Linder?
Yes, Your Honor. I spoke with Mr. Howes. Assuming the court finds probable cause on both counts, even though count one probably should be a battery, we agreed to a $1,500 bond on count one, a $2,500 bond on count two, and no victim contact.
Is that Mr. House?
Yes, Your Honor.
Okay. I do find probable cause for both counts. Count one being assault, domestic violence. Count two being false imprisonment of an adult. I do, upon the stipulation of the parties, I'll set the bond at $1,500 for count one. Count two will be $2,500. I'm going to order you, Mr. Bain, to not have any contact. And I'm sure that Mr. House, your attorney, will explain to you, not have any contact whatsoever with Miss Amy Ames. You're not supposed to contact her, and you're not to contact her through somebody else. You cannot, if you live together, well, I'm sure you've got this all covered, right?
Judge, yes, it's his house, and she will be out before he gets out.
Okay.
Okay? And just so I can tell him that his friend's going to be posting the bond, so he'll be getting out whenever the process gets done at the jail.
Okay.
Thank you, Your Honor.
You're very welcome,
see
sir.
you.
Good luck to you. Take care.
Thank you.
All right, so now we're going to take it from the top. Ethel Wallace.
She's in North Broward, Judge.
Oh, thank you. Ms. Ethel Wallace.
Front and center. There you go.
Good morning, Ms. Wallace. How are you?
Good morning, I'm doing well.
All right, good to hear. Ms. Wallace, you're being charged with touch or strike battery as a domestic violence, unless there's any probable cause argument.
No, Your Honor.
All right, I find probable cause for that charge as far as bond is concerned. Mr. Reedy?
Judge, Miss Wallace has been living here all of her life. She's the mother of 5 children, aged 33 to 21. She does not believe any of them are going to be able to assist her in bonding out. She has some medical issues that need to be addressed that may not be addressed properly in the jail. She has an apartment to stay in. She does not live with the alleged victim in the case, who stated that nothing happened and that he injured himself cutting trees, but she would not be having any contact with him in any event. They do not live together.
All right, Mr. Linder?
Your Honor, Ms. Wallace has been arrested 2013 in Dade County for aggravated assault, domestic violence. Actually, these are all in Dade. 1994 aggravated battery, 1990 aggravated battery. All cases were dropped. Your Honor, based on her previous arrest and the information provided by the independent witness, I would just be requesting a $1,000 bond and no victim contact.
Would the court consider pretrial release?
They don't live together?
No, Your Honor, they do not.
Mr. I don't even have the name of the victim
Yeah,
in this.
and
probable cause
that's why, Your Honor, what I'm asking, well, obviously we can't, the clerk cannot prepare a order of no victim contact. That's why we're asking for an order. If there is an issue later on, then we'll deal with it then. But
Okay. All right. All right, Ms. Wallace, I'm gonna order. I do find probable cause for the charge. I'm gonna order, Ms. Wallace, that you have absolutely no contact with the victim, whomever this male is. You're to have absolutely no contact. You're supposed to stay away from this victim and have no contact even with somebody else, even through somebody else. You cannot ask somebody else to contact this person for you. You cannot contact this person directly or indirectly. Understood?
Yes.
Okay, very good.
And
I'm about to do that. I'm gonna go ahead and order that Ms. Wallace be placed on pretrial release. I am RORing her, placing her on pretrial release to report to pretrial, just, I guess, Madam Pretrial, what is the, okay, you need to report to pretrial as soon as you're released, before 4 o'clock today. If you get released after 4 o'clock, you need to go tomorrow morning first thing. And I'm gonna order that she be placed on the least, I just want her to report to pretrial. All right. Thank you, Ms. Wallace. Good luck to you, ma'am.
Thank you.
So you want me to sign this one, even though there's no? Vivian Osorio Bustillo.
Judge, she requires the services of a Spanish interpreter. She is here at the main jail.
I
Okay,
ordered one, Judge. They're on their way.
very good. So we'll just place Miss Vivian Osorio Bustillo on a brief recall until the Spanish interpreter gets here.
And Judge, the next case, Mr. Thermostal, the list of victims is having trouble finding the courtroom. If we put on a brief recall.
All right, so on Pierre Thermostal, we're gonna put also on a brief recall.
We're gonna, I think somebody's coming on your behalf. Just have it. We'll call you back.
I don't think the next guy.
Yeah. Well, that. Just the next two matters on the docket also require the services of the Spanish interpreter.
So you're referring to Pedro Martinez?
Pedro Martinez, and I'm sorry, the one after him, Adrian Sanchez.
All right, so Pedro Martinez will put on a brief recall for the Spanish interpreter. And also Adrian Sanchez will put on a brief recall for the Spanish interpreter. All right, Anthony Martinez?
checking, is he still on loan?
Medical reset.
All right. Tomorrow? Tomorrow's the 14th? Yes.
Yes.
Nicholas Baird?
Conti?
This,
Conti.
Your Honor, this was it's actually supposed to be reset for the afternoon. It was a 30-day motion to release him yesterday. The problem was, for some reason, even though there's a felony charge, he was issued a misdemeanor case number. And I believe that was an issue for the jail. Okay, Brian, there's a felony case number now, if you want to prepare the order. Yeah, we'll take care of it now. Actually, I guess we're gonna have to do two orders. You're gonna need a new order on 172297 MM10A, which is battery, violation of injunction, domestic violence. And 17, what's that? They're both RORs. 174256 CF10A. Battery on battery on a 174256 CF10A. Battery on a person over the age of 65.
So he's being ROR'd on both charges because the state hasn't followed?
Yeah, but I think there's going to be a problem with this too, Brian. Because the clerk's office didn't put all 4 charges on the felony case.
Oh, there's,
When he was, Your Honor, when he was originally arrested, he was arrested on 4 charges, one of which was a felony. For some reason, he was given a misdemeanor case number. The jail advised us yesterday they wouldn't be able to release the order because there's a felony on a misdemeanor case number. So the clerk's office, we reset it for the clerk's office to create a felony case number. The problem is they only put 2 of the 4 counts on the felony case number, according to Odyssey.
all right, so let's do this on Mr. Beard. Let's go ahead and reset him to the afternoon like he was supposed to be. All right, Mr. Beard, I know it's a little bit inconvenient, but let's come back in the afternoon. Technically, there's a technicality where you're going to be ROR'd on the charges because the state hasn't filed their information. And we would have been able to take care of it all today, but all 4 charges that you're being held on are not
I don't know how they're going to do it.
in front of us right now.
The 2
So
remaining counts just have
we're going to
be
go
added.
ahead and see you back here at 1:30, okay?
Yes, ma'am.
I'll put it in
All
the
right.
notes.
Thank you.
You're very
I'll put
welcome.
the registered actions for you. No problem.
Now you see how we're trying to get rid of this.
So, Madam Clerk, I'll
The
give you
problem is
this.
that, and I hear you,
Get me the-
it's not my fault. They have a whole policy about when they,
All right.
you know. it's-
Tammy Johnson?
She's in North Broward, Judge.
All right, thank you.
Come on, Tammy.
Well, no. We already did one yesterday. No, we already did one yesterday. But, you know,
How are you, Miss Johnson?
Do anything about it.
Hi, how are you, ma'am?
I'm doing very well, ma'am.
Good morning.
Good morning.
Good morning, ma'am.
Good morning, thank you.
Yes, ma'am.
Miss Johnson, you're being held on 2 KPS's, 2 KPS misdemeanors for 2 separate cases. The bond that was set on those 2 cases for,
We just need them added to the bottom.
failing to appear at your arraignment date
That's a whole
is $100 on each bond, on each case.
Yes, ma'am.
So,
because
this is a municipal ordinance, so the public defender's office is not representing Miss Johnson, is that right?
That's correct, Your Honor.
Miss Johnson, do you want to, do you have $200?
No, I don't. But I will have it when I get out.
All right, Miss Johnson, do you want to resolve your 2 cases today?
Yes, ma'am. Please, ma'am.
All right, Miss Johnson, this is Hollywood. Oh, who's that, Mr. Shade?
Yes, that would be Mr. Shea, Judge.
Oh, we have to call Mr.
You
Shade?
can do whatever you want, Judge.
We don't know? All right, Miss Johnson, raise your right hand,
I would
please.
like me. Yes, ma'am.
I don't want it.
Okay, hold on just 1 second, Miss. You can put your hand down, Miss Johnson.
Yes, ma'am.
That's the second count, for loitering where sign is posted and aggressive panhandling. Well, actually, it's flipped over, yes. It's supposed to be 5-6 and 5-4, yeah, and it's 6-5 on the, right, so you want me to? Okay.
Judge, may I call a case out of turn? How long you let me talk?
Hold on, Foz, we're still doing Miss Johnson's
Oh,
case.
okay. All right.
Never mind.
Right, it was switched over, the 6-5 and 5-6. Okay, Miss Johnson, back on you. Would you please raise your right hand, ma'am?
We'll take care of it.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Sometimes I'm a little slow.
Yes, ma'am.
All right, you may put your hand down, ma'am. Miss Johnson, are you under the influence of any alcohol, medication, or drugs today?
I'll take care of it.
No, ma'am.
Okay, are you?
I
have
just
you
take me.
Have you ever been treated for a mental illness?
No, ma'am.
Okay. And
Schizophrenia.
what was that?
Schizophrenia.
Okay.
I take medication.
Are you taking medication for schizophrenia? All right. Now, have you ever been determined incompetent by a court?
It's a big.
Always been competent to proceed.
Okay. The medication that you're on, Miss Johnson, does it keep you from understanding what's going on here today?
No, ma'am.
All right. And have you been taking your medication like you're supposed to?
Yes, I do, ma'am.
All right. So that actually helps you understand what is going on here today better than it would if you weren't, right?
Yes, it does, ma'am.
All right. Very good.
Yes, ma'am.
I find Miss Johnson is coherent and aware of what's going on. All right, Miss Johnson, as to case number, are you on probation anywhere in the world, Miss Johnson?
No, ma'am, I'm not on probation.
Okay, and you understand, Miss Johnson, that by taking these pleas, if you're not a U.S. citizen, you will be subject to deportation?
Yes, ma'am, I understand, ma'am.
All right.
Yes, ma'am.
All right, very good. Miss Johnson, as to count one, which is on case number 17001356, MO40A, charges loitering where sign is posted. How do you plead, guilty or no contest?
No contest, ma'am.
Okay, I accept your plea. I find that you're fully voluntarily intelligent. We have your rights. I find that you're competent here to learn. I find that you know and understand this plea and understand the nature of the charges and the consequences of the plea. After reviewing the charging document, I find that there's sufficient facts to be free plea and sentence you according to the negotiated to a withhold of adjudication and court costs. I'm going to give you 6 months to pay those court costs. I believe the court costs for these cases are what, $70? 78. All right, Miss Johnson, as to count two, which is 17001354 MO40A, that charge being aggressive panhandling in the highway, how do you plead, guilty or no contest?
No contest, ma'am.
Okay, I accept
No
your plea.
contest.
Okay, I accept your plea. I find that you're fully voluntarily intelligent. We have your right to find that you're competent here to learn. I find that you know and understand the nature of the charges and consequences of the plea. After reviewing the charging document, I find that there's sufficient facts to be free plea and sentence you according to that to the withhold of adjudication and court costs. All right, Miss Johnson, you should be released today. Okay.
Okay, thank you, ma'am. Thank you so much, ma'am.
You're very welcome. Take care.
Judge, may we call a case out of turn?
Sure.
Patrinda Duversi. She's charged with touch and strike battery, and she has 2 capiases from Judge Bailey's division.
Velasco?
Okay. What is the last name again?
Duversi.
Okay, I found her. All right, Miss Patrinda Duversi.
Yeah. Yes, Judge.
Is she at me?
I'm right here.
Okay, sorry. All right, Ms. Diversey, you're being charged with count 1 is touch or strike battery, and you have 2 capiases that were signed by Judge Dennis Bailey. I find probable cause for the capiases that were signed by Judge Dennis Bailey. As to count 1, any probable cause argument?
No, Your Honor.
All right, I find probable cause as to count 1. As to the bond on count 1. Anybody want to be heard on that?
I'm just asking.
Judge, I'm going to stand me.
I'm sorry?
I'm judging in light of the fact that she has no bond holds. I would ask the court to keep the bond the same.
And that's all I'd ask. The other thing I'd ask is an order of no victim contact, Judge.
Okay. We'll go ahead and I'll leave the bond at $1,000 that is set right now, the convenience bond. And I'm going to order, Ms. Duversi, that you have absolutely no contact with Ms. Sheila Valeria Solms. You understand that?
Great grandmama.
You understand that, Ms. Duversi? Okay, so I can assume you're not going to have any contact with her? Okay, very good. All right, thank you, Ms. Duversi.
I got $1,000 bond.
You're being held.
My niece is only 7 years old. She won't see her father until she's 16.
All right, Shanta Donald.
That's North Broward, man.
All
North
right.
Broward.
But I have to take care of her children.
All right, Ms. Shanta Donald, how are you doing today?
I'm a little okay, but I would like to ask for pre-trial so I can be accountable when I get out of jail.
All right, well, let's go ahead and talk about... Okay, hold on a second, Ms. Donald. You're being charged with criminal mischief. $200
Yes, ma'am, but I
less as a... Wait, let me talk. Don't interrupt me, ma'am, okay?
Yes, ma'am, sorry.
Thank you. You're being charged with criminal mischief, $200 or less as a first offense. I find... any probable cause argument?
No, ma'am.
All right, I find... No, ma'am, you need to let me talk.
Oh.
I will give you an opportunity to talk, but you need to let me talk. In fact, you have representation, so I'm going to ask you to not talk to me about the facts of the case, but I'll give you an opportunity to talk. Please do not interrupt me again. I find probable cause for the charge of criminal mischief. As far as the bond, right now it's the convenience bond is $25. What would you like to say, Miss Donald?
Ma'am, I know they charged me with criminal mischiefs, but those girls was trying to jump me,
Okay,
and I
nope,
couldn't even
don't
make
talk
it.
to me. Nope, don't talk to me about the
Oh,
facts of the
oh,
case,
okay,
Miss Donald. So here's
I
what's going to
apologize
happen.
for
I'm going
that.
to order.
I apologize.
Mr. Reedy, would you like to be heard?
I know Miss Donald, Judge. I don't know what her living arrangements are right now. I'd ask the court to consider the possibility of an ROR.
She just got ROR'd on Tuesday on a criminal mischief.
But that's where I know her from.
All right, Miss Donald. State what's your position on the bond?
Your Honor, I think at a minimum, the $25 bond should be kept, needs to be kept in place, considering was out about 36 hours.
All right. I'm going to go ahead and leave the $25 bond in place, and I'm going to order, Miss Donald, that you have absolutely no contact with S. Parkle Clark. Whatever that is. Apparently it's the victim.
I think it's in a...
Nope,
okay.
do not speak, ma'am. This is a non-adversarial hearing. This is for purposes of setting your bond and finding probable cause for the charges. It's not a give and take. It's not a Q&A. Mr. Linder?
Yeah, it's actually, Sparkle Clark. I was just like, it's easier to read on the victim notification form.
No contact with Sparkle Clark. Yeah. All right, thank you very much, Miss Donald. Good luck to you.
May I speak to my lawyer?
You may speak to your lawyer when he comes to see you. I'm sure he'll come to see you very soon. Mr. Reedy's here, and then we'll be able to discuss this case further, okay? Good luck to you, ma'am.
How long is it going to take him?
I don't know, ma'am. I have other people. We have about 75 or 100 other people that need to be addressed to today, this morning,
Yes,
okay?
ma'am, but I have the bond money, but my sister's my payee is what I'm trying to tell you.
Okay, thank you, ma'am. Thank you, ma'am. Miss Donald, we're done. Janae Martin?
Paul Ryan.
Paul Ryan.
All right, Miss Martin, how are you doing this morning?
I'm fine. Good morning.
Good morning. Miss Martin, you're being held on a capias for felony case number 1700319 CF10A. The bond that was set by that particular judge is $3,500. I can't disturb that because it's already preset. And the good news is that you will go see the division judge on April 24, 2017 for that charge. I find probable cause for that capias. Good luck to you, Miss Martin.
All right. Thank you.
You're very welcome, ma'am. Shannon Grog? Where's Miss Grog?
Right after this one. Right after this, I'll let her down. And, Your Honor,
Yes.
after this case, we have the Spanish interpreter present in court.
Oh, perfect. Shannon Grog? It says that she's at the main jail.
She's here.
Okay. All right, well, good morning, Miss Grog. Miss Grog, you're being held on a capias for felony case number 160-15051 CF10A that was signed by Judge Colraw. You're being held no bond on that case, so I can't disturb that. The good news is that you're going to go ahead and see Judge Colraw or your division judge on April 18, 2017 at 8:30 a.m. I find probable cause for the capias. Good luck to you, ma'am.
Thank you.
You're welcome. I have the Spanish interpreter present. How are you, sir?
I have
All
another
right,
one.
so let's call Vivian Osorio Bustillo. All right, Mr. Interpreter, would you please raise your right hand? Do you swear or affirm that the translation from English to Spanish or from Spanish to English shall be true and to the best of your ability?
I do.
All right, you may put your hand down. All right, Miss Osorio Bustillo, we have an interpreter here present that's going to help you with this proceeding.
Señora Osorio Bustillo, tenemos aquí un intérprete que le va a ayudar con este trámite.
All right, this is Magistrate Court, and the purpose of this hearing is to find probable cause for the charge.
Esta es la audiencia de lectura de cargos y el propósito de esta audiencia es para hallar fundamento probado en cuanto a los cargos
And to determine any pretrial release conditions, including but not limited to the amount of your bond.
y determinar cualquier condición de salir ante juicio, incluyendo, pero no se limita, a el monto de su fianza.
All right? So, Ms. Osorio Bustillo, you are charged with touch or strike battery as a domestic violence.
Así que, señora Osorio Bustillo, usted se le acusa de agresiones físicas por tocamientos o por haberle pegado a alguien en un contexto de violencia en el hogar.
All right. Any probable cause argument on behalf of Osorio Bustillo?
¿Algún argumento de fundamento probado en cuanto a la señora Osorio Bustillo?
No. All right. I do find probable cause for the charge of touch or strike battery domestic violence.
Hallo de que hay un fundamento de hechos para el cargo de agresión física con tocamientos o haber pegado en un contexto de violencia en el hogar.
All right. In addition, Ms. Osorio Bustillo, in addition to the bond that we're going to talk about in a little bit, I'm going to order that you have absolutely no contact with Pedro Martinez. Do you understand that?
Señor Osorio Bustillo, aparte de la fianza de la cual vamos a hablar en un momento, también le ordeno de que no tenga ningún contacto con el señor Pedro
Martinez.
Con el señor Pedro Martínez. ¿Entiende usted eso?
And, Your Honor, if I may, it appears that both parties were arrested. So I think what I would be requesting, I think it's a fair compromise. I checked. Oh, sorry, go ahead. Sorry.
Perdóneme, su señoría, me doy cuenta aquí que ambas partes fueron arrestadas, así que lo que yo quiero pedir de manera que me parece justa.
Neither party has a criminal record, so I have no objection for RORs for both.
La otra parte tiene un historial penal, así que no tengo ninguna oposición en contra que le dejen salir abajo bajo palabra de juramento.
I would be requesting that both parties receive an order of no physical contact.
Voy a estar pidiendo de que ninguna de las dos partes tenga contacto físico.
I have no objection to telephone contact being allowed so they can set up living arrangements.
Y no tengo objeción con que tengan contacto telefónico para que puedan hacer arreglos en cuanto a la vivienda.
All right, Miss Osorio Bustillo. You live with Mr. Martinez?
Señor Osorio Bustillo, ¿usted vive con el señor Martínez?
Sí, sí vivo.
Yes, I live.
Okay, so here's the deal. If I release you on your own recognizance with me, which means with no monetary bond.
Si se le acuerda lo siguiente, si yo le dejo salir usted bajo palabra de juramento, lo cual quiere decir que no sería una fianza económico-financiera,
then you're going to have to find somehow both you and Mr. Martinez to live separately.
usted va a tener que encontrar de alguna manera donde usted y el señor Martínez puedan vivir de manera separada.
Is that going to be a problem?
¿Eso le causará un problema?
Bueno, por ahora no sé, tendremos que hablar eso para poderlo buscar.
Well, right now I don't know. I guess we'll have to talk about that to be able to find it.
And, Your Honor, that's why I have no objection to telephone contact.
Y por eso, su señoría, no tengo objeción con que tengan contacto telefónico.
Oh, this isn't a house going
Yeah, and I'm not going to put their ages on the record, but certainly I think two adults of their age could, in communication, can figure out a way where one of them can stay somewhere else.
Y no pondré en las actas la edad que tienen, pero estoy seguro que siendo adultos ambos pueden hablar sobre dónde conseguir una vivienda.
Miss Osorio Bustillo, do you have any family here that lives in Broward County?
Señor Osorio Bustillo, ¿usted tiene familia que vive aquí en el condado de Broward?
No.
No.
Do you have any family that lives in Florida?
¿Tiene familia en la Florida?
Sí.
Yes.
Where?
¿Dónde?
Kendall.
Kendall?
Okay, so I know that it's going to be a little bit of a drive, but that may be one of your options that you may want to explore.
De acuerdo, bueno, yo sé que eso le causará un poco de tiempo conduciendo, pero parece que esa sea una de las opciones que puede explorar.
If Mr. Martinez is not able to find an alternative place to live.
Si el señor Martínez no puede encontrar vivienda alterna.
All right, so I'm going to ROR Miss Osorio Bustillo. That means that I'm going to release her on her own recognizance.
De acuerdo, entonces voy a dejar salir a la señora Bustillo bajo palabra de juramento.
And I'm going to order Miss Osorio Bustillo that you have absolutely no contact with Pedro Martinez. I will allow you to contact him via telephone.
Y le voy a ordenar, señor Osorio Bustillo, de que no tenga contacto con Pedro Martínez. Le voy a permitir de que le hable por teléfono.
To discuss your living arrangements, but that is it.
Para hablar sobre los arreglos de vivienda, pero eso es todo.
You understand, if you have any contact with him, contrary to this court order, you may be looking at additional criminal charges.
Usted se da cuenta de que si usted tiene contacto adicional con él en contravención de esta orden del tribunal, usted podría estar enfrentando cargos adicionales.
Sí.
Yes.
All right, very good.
De acuerdo, muy bien.
All right, Ms. Osorio Bustillo, you should be released at some point today. Good luck to you, ma'am.
De acuerdo, señor Osorio Bustillo, usted ha de salir en algún momento hoy. Buena suerte.
Gracias. Gracias.
You're welcome. Pedro Martinez.
Bernard Grant.
All right, Mr. Martinez, you're here for magistrate court, as you previously heard me explain to your co-defendant,
De acuerdo,
Ms. Osorio Bustillo.
Señor Pedro Martínez, usted está aquí para el Tribunal de Magistrado. Como usted oyó, cuando le expliqué a su coacusada, la señora Osorio Bustillo.
So consistently with that previous ruling, I'm going to go ahead and find probable cause for the charge of touch or strike battery domestic violence.
Concordando con esa orden previa, voy a hallar fundamento probable al hecho de tocamientos físicos, agresión en contexto de violencia en el hogar.
All right, I'm going to go ahead and ROR Mr. Martinez on the charges.
Sobre estos cargos voy a dejar salir al señor Martínez bajo palabra de juramento.
And I'm going to order Mr. Martinez that you have absolutely no contact with Vivian Bernarda Osorio Bustillo except for telephone contact to arrange a living arrangement during the pendency of this case.
Y le voy a ordenar, señor Pedro Martínez, de que no tenga contacto absoluto con la señora Vivian Bernarda Osorio Bustillo, salvo para hacer arreglos en cuanto a la vivienda durante que esté pendiente estos cargos penales.
Do you have family in this in Broward County, Mr. Martinez?
¿Usted tiene familia en el condado de Broward, señor Martínez?
Yes.
Okay, very good. So perhaps you may be able to find an alternative living arrangement.
De acuerdo, entonces probablemente pueda ser que sea usted quien encuentre vivienda alterna.
Okay, very good. All right, Mr.
She can stay in the house. She can stay in the house.
She can stay in the house?
Yes.
Okay,
I don't got problem
that's
with
very
that.
nice of you. Okay, that's good. All right. If she's still there, Mr. Upsall, can you just relay that? No, you can't talk to her. See, you can't communicate with her.
She left.
Oh, she left already? Okay. All right, well, I'm sure somehow she'll get that
I'm
information.
sure he'll call her and tell her.
Okay, very good. All right, Mr. Martinez, good luck to you, sir, okay?
Thank you.
You're welcome. All right. Adrian Sanchez? Mr. Sanchez, we have the assistance of the interpreter here for you.
Señor Sánchez, tenemos la ayuda del intérprete aquí para usted.
And as you heard me previously explain to the previous gentleman and young lady, this is magistrate court.
Como previamente me oyó a explicarle al caballero y a la dama joven, este es el Tribunal de Magistrado.
And unless there is any probable cause argument regarding the charge of domestic battery by strangulation.
None.
None? Okay.
Y al menos que haya un argumento en contra del fundamento probable del cargo de agresión en el hogar mediante estrangulación.
All right, I find probable cause for the charge of domestic battery by strangulation.
Fallo de que hay fundamento probable para el cargo de violencia en el hogar mediante estrangulación.
And in a moment, Mr. Sanchez, we're going to discuss your pretrial release conditions, including but not limited to the bond amount, if any.
Y en un momento hablaremos sobre las condiciones de salir ante juicio, incluyendo, pero no limitándose a alguna fianza financiera, si habrá una.
And but I want to inform you, Mr. Sanchez, that you are to have absolutely no contact with the victim in this case.
Pero le quiero informar que no ha de tener ningún contacto absoluto con la víctima en este caso.
The victim, Miss Natalia Velez. Understood?
La víctima siendo Natalia Vélez. ¿Entiende usted eso?
Sí.
Yes.
Yes.
Okay. Do you live together?
¿Viven juntos?
No. I don't see her for a long time ago, like 9 months ago.
Okay. Very good. So then that won't be a problem. I'm going to order, Mr. Sanchez, that you have absolutely no contact with her. You cannot contact her directly or indirectly. If you do, you understand that you may be exposing yourself to additional criminal charges. You understand that, sir?
Yes.
Apparently he understood. All right. So as far as the bond is concerned, Mr. Reedy?
I didn't have any conversation with him, Judge.
Oh, Mr. Afzal?
Judge, I had limited conversation with him. He informed me that he would feel more comfortable with the Spanish interpreter. That's why I requested one for him. But
Okay.
I had I have no objection if the court wants to inquire as to the ties, or I can inquire through the interpreter.
I'll allow you to inquire through the interpreter if you want.
Mr. Sanchez, in what city do you currently reside?
Señor Sánchez, ¿en qué ciudad reside actualmente usted?
Tamara.
Do you live in a house or apartment?
House.
Do you own the house?
No, rent.
Your Honor, the interpreter doesn't know how to proceed.
All right, Mr. Sanchez, here's the deal. If you have the assistance of the interpreter, you need to let the interpreter interpret for you. If you don't need the assistance of the interpreter, then you can go ahead and proceed without the interpreter, but you can't, in the middle of that, say, oh, I need the interpreter, or I don't. It'll just confuse the whole proceeding. So do you want the interpreter?
Yes.
Okay.
Sí.
All right, so go All right, so go ahead. He'll do his best. I'm sure Mr. Sanchez will do his best. Go ahead, Mr. Abdal.
Are you working?
¿Está trabajando?
Sí.
Yes.
What do you do for work?
¿Qué es lo que hace para trabajar?
Manejo, conductor.
I drive, I'm a driver.
How much money do you make doing that job?
¿Cuánto dinero gana haciendo ese trabajo?
La semana 600, depende.
A week, 600, it depends.
Do you have any money in the bank? Any money saved up for bond, to post bond?
¿Tiene dinero en el banco? ¿Dinero ahorrado para fianza? ¿Para prestar una fianza?
No, pero mi familia me puede ayudar.
No, but my family can help me.
How much can they afford to bond you out?
¿Cuánto dinero pueden costear ellos para sacarle bajo fianza?
No sé, porque casi no tengo plata.
I don't know, because I don't have any dough.
How much are your bills monthly?
¿Cuánto tiene de las facturas en cuanto mensualmente?
Yo tengo que pagar todo. Tengo que pagar el carro, la renta, electric bill. Tengo que pagar todo. El teléfono, todo.
I have to pay for everything. I have to pay for the car, the electric bill, rent. I have to pay for everything. I have to pay for electricity.
What's the most you can? Sorry. What's the most you can afford in bond? Is there anything you can afford in bond?
¿Cuánto es lo máximo que usted puede costear en fianza? ¿Hay algo que puede costear usted en fianza?
Sí, pero en este momento no que no sea mucho, que no tengo casi plata.
Yes, but at this moment, as long as it's not a whole lot, because I almost don't have any money.
How long have you been living at the Tamarack residence?
¿Cuánto tiempo lleva viviendo en esa residencia en Tamarack?
Como de diciembre.
From December?
Sí.
Who lives there with you?
Yes. ¿Quién vive ahí con usted?
Yo vivo solo.
I live by myself.
Judge, if he doesn't have an extensive history and the victim doesn't reside with him, will the court consider pretrial release so he can work?
Si él no tiene un historial alargado y la víctima no vive con él, ¿consideraría el juez dejarle salir bajo servicio ante juicio?
Mr. Linder?
One, I don't believe straight pretrial release is permitted by statute when there's a dangerous offense, and I believe strangulation would satisfy that.
Yo creo que bajo el estatuto legal no se permite salir bajo servicios ante juicio simple, dado la acusación de violencia, de estrangulación.
Mr. Sanchez has no criminal record.
El señor Sánchez no tiene historial penal.
That being said, the level of violence alleged,
Habiendo dicho eso, el nivel de violencia que se alega
and the alleged threat he made regarding the victim's family,
y el alegato en cuanto a las amenazas que le hizo a la familia de la víctima,
Your Honor, the state would be requesting a $7,500 bond and no victim contact.
la fiscalía estará pidiendo una fianza de $7,500.
Judge, will the court consider $2,500? It's difficult for me to put a monetary amount on the bond where he says he's getting help from his family and that most of his money is tied up in bills. I feel $2,500 with no criminal record would be fair.
Considerar al juez una fianza de $2,500. Se me hace difícil fijar una fianza cuando él se pasa la mayor parte de su tiempo y su dinero ayudando a su familia. 2,500 me parece a mí que sería justo.
All right,
So that's good.
did I already instruct him to have no contact?
Yes, Your
with
Honor.
them? Okay, yes.
Yes.
All right. And he's the one that said he hadn't seen her for 9 months?
Yes.
Says.
Right. Okay. So you're not in a relationship with her anymore?
Así que ya no está en una relación con ella.
No, todo terminó hace tiempos.
No, everything ended some time ago.
Okay, very good. So there's no risk of that.
De acuerdo, entonces no hay riesgo de eso.
Okay, I'm gonna go ahead and set the bond at
Voy a fijar la fianza
$4,000
a $4,000
and no contact with the victim.
y no puede tener contacto con la víctima.
All right, thank you.
De acuerdo, gracias.
Would you like, Sir Interpreter, would you like to make an announcement so that you can?
¿Hay alguna otra persona que requiere los servicios del intérprete en español?
Sí.
What's the name, Mr.?
¿Cuál es el nombre?
Christopher Fonseca.
All right, where is that?
Page 15.
Página 15.
James Fonseca.
Christopher Fonseca? Yeah. Christopher.
Christopher.
Yeah.
All right, Mr. Fonseca, you're here for Magistrate Court, as you heard me previously explain to the previous individuals.
De acuerdo, señor Fonseca, usted está aquí para el Tribunal de Magistrado, como me oyó explicarle a los previos acusados.
Sir, you're being held on a violation of probation,
A usted lo tienen acá por haber quebrantado su libertad probatoria
and you're being held no bond on that case.
y por ese caso no tiene fianza.
I find probable cause for the violation of probation warrant, and I cannot disturb the no bond, sir. So you will be held no bond.
Fallo de que hubo fundamento probable para el cargo de haber quebrantado su libertad probatoria y eso es un cargo que no conlleva fianza y yo no puedo cambiar eso, lo tienen sin fianza.
Until, sir, you go see your division judge on April 18th at 8:45.
Eso será hasta el 18 de abril a las 8:45 cuando usted verá al juez suyo de lo penal.
Thank you, sir.
De acuerdo, gracias, señor.
All right, you want to go ahead and make an announcement?
¿Alguna otra persona requiere servicios del intérprete en español? No takers.
Judge, we have a Creole interpreter.
Yes, Judge, we have one more.
Okay. All right, what's his name, Mr. Afzal?
I don't know yet. You're
Arturo Joel.
Arturo Joel.
Page 24.
Page 24.
Thank you.
If it's a zero, it's a zero. Do you work? With a zero. You get it with
Joel Arturo.
I have it right here.
It's Joel Arturo.
Joel Arturo. All right, Mr. Joel Arturo, you're here for Magistrate Court.
De acuerdo, señor Joel Arturo, usted está aquí para el Tribunal de Magistrado.
As you've heard me previously explain to the previous individuals,
Como previamente usted me oyó explicarle a los individuos previos.
this is a non-adversarial hearing.
Eso es una audiencia no adversaria.
So, sir, you're being charged with grand theft
Así que, señora, usted se le está acusando de hurto mayor
as a first-degree misdemeanor and touch or strike battery.
como un delito menor en primer grado y también de agresión por tocamiento o por haber pegado.
All right, unless there's any probable cause argument.
There does not appear to be one, although Mr. Arturo's statement that he committed the offense because he wanted to get arrested causes me some concern, Mr. Azul.
Al menos que haya un argumento de fundamento probable, no lo hay en el momento, aunque la declaración que dio el señor Arturo que quería conseguir que la arrestaran me causa una preocupación.
Is that something we should be making a note of?
Hemos de hacer apunte en cuanto a ello.
I'll have Sue speak with him to get more information.
Okay.
Hablaré con él para conseguir más información.
All right, so I find probable cause for both charges, count 1, grand theft, and count 2, touch or strike battery.
Fallo de que hay fundamento de hechos para ambos cargos, el primer cargo de hurto mayor y el segundo cargo de agresión física.
And as far as bond is concerned,
Y en cuanto a la fianza,
Mr. Upsall, you want to inquire?
Sure, Judge. Señor Arturo, where do you currently reside?
señor Arturo, ¿dónde reside actualmente?
May I have the pen, please? Thank you. Have a seat.
Señor Arturo, ¿dónde reside actualmente?
Por orden.
He said Fort Lauderdale.
I need him when he's
You live in a house or apartment?
¿Vive en una casa o un apartamento?
Un apartamento.
Apartment.
Christian Adams?
How long have you lived at that apartment?
¿Cuánto tiempo lleva viviendo en ese apartamento?
3 meses.
3 months.
Are you working?
¿Está trabajando?
Sí.
What do you do for work?
¿Qué es lo que hace para trabajar?
Finish driver.
I'm sorry, the interpreter wasn't able to hear that.
Finish driver. Finish driver.
Drywall?
Drywall. How much money do you make doing that?
¿Cuánto dinero gana haciendo eso?
Como hungry. Como hungry, 100.
100?
Sí.
Can you afford any money towards bond?
¿Usted puede costear algún dinero hacia una fianza?
No sé.
I don't know.
No.
Do you have any family or friends in Broward County?
¿Tiene familia o amigos en el condado de Broward?
Sí.
Yes.
Do they know you're in jail?
¿Saben ellos que usted está en la cárcel?
Sí.
Yes.
Would they bond you out of jail?
Ellos podrían prestar la fianza para que usted salga de la cárcel.
No sé. ¿Cuánto es?
How much is it?
2,000 right now.
Ahora son 2,000.
Normally that's 10%, $200 to a bond spend with collateral.
Normalmente es el 10%, así que serían $200 a un fiduciario con materia colateral.
Can you afford that?
¿Eso lo puede costear?
Brian, can you pick up the phone briefly?
I can in 1 second, but someone's on it right now.
Your Honor.
All right, Mr. Arturo, how long have you been living in Broward County?
Señor Arturo, ¿cuánto tiempo lleva viviendo en el condado de Broward?
Como 6 años.
Like 6 years.
Okay.
Your Honor.
And who do you live with?
¿Y con quién vive?
Con amigos.
With a friend.
Your Honor. I'm going to be requesting, the state's going to be requesting that the bonds be kept in place.
La fiscalía va a pedir que la fianza permanezca fija.
The problem is the answers he's giving are pretty general, considering the information he gave the officers that he's at large and doesn't have a residence.
El problema es que las respuestas que está dando no concuerda con lo que dijo el oficial de que vive, que está sin techo y que no vive en un lugar en particular.
Also considering when apprehended, he gave a fake name and fake date of birth.
También considerando que cuando lo detuvieron, dio un nombre falso y también una fecha falsa.
I just have concerns about his future appearance in court.
Por lo tanto, me preocupa su capacidad de comparecer al tribunal en el futuro.
All right, Mr. Absal, you want to talk to Mr. Reedy? I believe the phone's available now.
We've already spoken
Oh, you did? Wow, you're quick.
with our wonderful person over there, Aunt Sue, who signs people up at the PD's office.
Very good.
Judge, all I would say is this: is that there's nothing indicating that he would fail to appear in court. Nothing at all. Yes.
And I don't know, here's my concern, Mr. Absal. I don't know if it's the, and I'm not saying the Spanish interpreter is not interpreting properly, but go ahead, say that.
Solo quiero decirte que no hay motivo por el cual no ha de pensar de que él no ha de comparecer al tribunal. Bueno, no estoy diciendo lo contrario, pero estoy diciendo, no sé si es un problema con el idioma, no estoy diciendo que el intérprete no está haciendo buena labor en traducir.
His answers aren't very convincing.
Pero las respuestas que da él no me convencen, no son muy convincentes.
In the sense that he takes too long to answer questions that should be readily available.
Toma demasiado tiempo en responder una pregunta que ha de ser fácilmente respondida.
And it is possible that it could be because he's nervous or because there may be some other issues that are going on.
Y pueda que sea porque está nervioso o pueda que sea porque hay otros temas que están pasando.
So what can I do?
¿Qué puedo hacer entonces?
Well, you can leave the bonds where they are. You can put them on pretrial release. You can raise the bonds.
Well,
you
no,
can
I'm not gonna
borrow them. You can.
He's also used the alias Emmanuel Aguilar with a different date of birth in the past also.
También ha usado el nombre de Manuel Aguilar con otra fecha de nacimiento en el pasado.
And, Your Honor, being deceptive with law enforcement, giving aliases, I think is evidence that there should be a concern about his future appearance in court.
Y ser engañoso con las autoridades del orden público, dar fechas de nacimiento falsas, yo creo que eso sí es una preocupación en cuanto a su capacidad de comparecer en el tribunal en el futuro.
Okay, I'm going to go ahead and leave the bonds at $1,000, but I'll allow for them to be modified if there obviously a change in circumstances that is discovered. Then I have no issue if that. You can pull the recording and regarding.
Judge, with the court,
De acuerdo,
with the
voy a
court
permitir que la fianza permanezca a los $1,000, pero no tengo ningún problema con que eso sea modificado en el futuro si surge alguna nueva información.
Will the court appoint the public defender's office to represent him?
Yes, I appoint the public defender's office to represent.
Y el tribunal le asigna al abogado de oficio que le represente.
Okay, thank you very much.
De acuerdo, muchas gracias.
All right, sir interpreter. Anybody else need the assistance of the Spanish interpreter over at main jail?
En la cárcel principal, ¿necesita alguien más la ayuda del intérprete en español?
Nope. All right,
No.
very good. Let's go to Conti. Anybody at Conti need the assistance of the Spanish interpreter, deputies?
I don't think we have anyone left up there, Judge.
Oh, very good. Let's go to Paul Ryan. Anybody in Paul Ryan need the assistance of the Spanish interpreter?
No, Judge.
All right, thank you very much. And let's go to North Broward. Anybody in North Broward need the assistance of the Spanish interpreter? You want to say it in Spanish just in case?
Una persona requiere los servicios del intérprete en español.
We're good in North Broward.
All right, thank you very much, Deputy. Have a good day. All right, sir interpreter, thank you very much.
And,
very welcome.
Your Honor, we can, if it please the court, we can proceed now on Pierre Thermistal.
Oh, very good.
I mean,
Okay.
I believe we have an interpreter and present in court also.
All right, Mr. Thermistal, Pierre Thermistal. Okay, sir interpreter, would you please raise your right hand? Do you swear or affirm that the interpretation from Creole to English and English to Creole shall be the
Put your hand down.
and to the best of your ability? All right, you may put your hand down. Thank you very much.
Okay.
All right, and
Judge, I just want to let you know he declined the public defender. That's what I've been advised.
okay. All right, and does Mr. Thermistal need the interpreter?
Wait.
Yes.
Okay. All right, so Mr. Thermostal, this is magistrate court.
Donc, Monsieur Thermostal, donc ça c'est tribunal magistrat.
This is a non-adversarial hearing.
Donc, ça c'est un tribunal, donc il n'y a pas aucun adversaire là-dedans.
The purpose of this hearing is to find probable cause for the charges.
Raison que nous venons là aujourd'hui, c'est pour démontrer si vous avez une bonne raison pour l'accusation que vous avez sous dos.
Your Honor, I apologize. If you could ask me if they can try to keep it down at the jail, because I hear a background noise and it can be difficult.
Can you kill your mic, Foz?
Demandez pour rester pour yo appeler là parce qu'il y a un peu de bruit derrière d'eau.
Thank you, bro.
Mr. Afzal, can you turn the mic off while the interpreter's interpreting?
Donc, yo demandez pour fermer microphone là pour nous pas entendre le bruit ça yo.
Judge, the mic was off.
Oh, so that's...
It's coming from somewhere else. Yeah. Can all the facilities shut their mics off, please? There we go.
Okay. Oh, there you go. Yeah, that has been a little bit background noise. Okay. And also the purpose of this hearing is to set any pretrial release conditions, including but not limited to a bond, a monetary bond, if any.
So donc, et l'autre objectif que nous avons fait aujourd'hui, c'est pour établir conditions pour yo laguer, yo capable laguer sous ça yo les papiers dette ou soit caution.
So when I talk to you, Mr. Thermostal, about the charges, I'm going to ask, very important, that you not talk to me about the facts of the case. That is not the purpose of this hearing.
So donc, les commencer par là avec ou soit accusation que yo mettez sur vous, c'est très important pour ou pas commencer par le détail concernant cas qui j'en la passé.
Additionally, everything in this courtroom is being recorded, and it can and will be used against you in the future if you make any admissions.
So donc, en plus de ça, connaît que n'a enregistré toute bagage qui a passé, qui a dit là. So si vous t'as admettre ou soit si vous t'as dit que vous t'as fait un bagage, vous pouvez utiliser ça contre à l'avenir parce que vous avez enregistré tout bagage là.
All right. So, Mr. Thermostal, you were charged with touch or strike battery as a domestic violence.
So donc, Monsieur Thermostal, l'accusation que vous avez sur c'est que vous t'es frappé, ou t'es manié, fait agression, violence à domicile.
All right, I find probable cause for that charge, Mr. Thermostal.
Et il remarque que il y a une bonne raison pour l'accusation ça yo.
As far as the monetary amount and bond, the state will have an opportunity to speak, and you also have someone here.
Et en plus de ça, quand t'as pour comme que vous gagnez pour payer pour laguer papier dette là. Donc nous avons un monde là qui l'a pour.
Are you Miss Daphne Thermostal Monsu?
Est-ce que c'est vous-même qui Daphne Monestal Monsu? Yes.
Okay. Miss Thermostal, I'm going to give you an opportunity to address the court.
Madame Thermostal, donc n'a pas une opportunité pour adresser le tribunal ça.
But I'm going to ask that you not talk to me about the facts of the case.
Donc, il est très important pour pas parler de détails sur fait ça que ça t'est passé avec elle.
If you start, I will stop you immediately because that is not the purpose of this hearing.
Si vous commencez par le détail, la camper dans mi-temps phrase parce que c'est pas objectif pour me la parler ça.
All right. So, Mr. Thermostal.
Donc, Monsieur Thermostal.
All right, let's hear from the state, Mr. Linder.
Donc, parler d'abord.
Your Honor, if I could just very briefly ask the witness a couple questions.
Donc, tout bref.
It's not about this incident.
Okay.
Parler
All right.
ensemble avec témoin qui l'a posé quelques questions. Tout bref.
You may.
Ms. Thermostal Monsieur, it's alleged that Mr. Thermostal made a threat against you while this was happening. Has he ever made any threats against you in the past?
So donc, Madame Thermostal, monsieur, donc nous comprenons que Monsieur Thermostal, ça a été fait, il était menacé, les barres ça t'a passé. Est-ce qu'il déjà a fait une menace déjà? Yes.
Could you please tell the court about the threats he's made against you in the past?
Est-ce que vous capable de dire au tribunal là qui sont des menaces qu'il a fait avec dans le passé? He said that he would kill me.
Just once in the past, more than once?
Est-ce qu'il a fait ça une seule fois ou ça plus fois? He does this all the time. All the while I'm in the house with him, he's always threatening to kill me.
And at present date, are you in fear of Mr. Thermostal?
Pour kounya la, est-ce que ou gen bon jan la Perez de M. Temastal?
Yes, mwen peli paske li di famili ki la tue, fò l tue quand même.
Yes, I am afraid of him. He's not only told me, but he's told his family that he will kill me.
Mba mèm konde kote li rete.
I don't even know where she lives.
Okay.
Li gen 3 mwa
Mr.
depi li kite la
Thermostal,
kay
stop.
mwen.
Kampe la.
Stop.
Okay.
You will have an
Okay.
opportunity to speak. Do not interrupt this proceeding.
Okay,
Understood?
okay.
Donc, wap gen ti chans
Understood.
pou pale, men pa jam koupe parol yo pendant ya pale kounya la.
Okay.
Thank you. Mr. Linder.
Thank you, Your Honor. Your Honor, I show in 2004, Mr. Thermostal was arrested in Collier County for domestic violence battery. That was dropped.
So, donc, nou remarke nan 2004 ke M. Temastal yo te arete pou kou ke li te bay, e yo te mette akizasyon sa yo, men a la fin yo te lage akizasyon yo.
I see no additional record.
E li pa wè oken lot bagay sou dosye.
That being said, Your Honor, I'm going to be requesting a bond in the amount of $10,000.
So, donc, avek sa, donc, na pamande pou li paye yon papye dette de $10,000 pou yo lage.
Pretrial release with a GPS monitor.
Et yo kapab lagil s'il ta paye caution sa avec yon GPS bracelet sous pied.
And obviously no victim contact.
Et c'est sûr que li pa gen doit gen contact avec victime.
I have great concern for the safety of the alleged victim.
Donc, nou pli souci pour sécurité victime nan.
Not only based on the allegations in the affidavit, but also her testimony today.
So, donc, non seulement à cause de sa ki te di la jodi a témoignage li, accusation et papier qui te fait, laisse a te fait.
And Your Honor, I would just note as what I believe to be an additional aggravating factor.
Donc, et on autre bagay que m'ta remè ke okeme nan tête ou ki kapab escale bagay yo.
While these allegations support a charge of battery, and that's what he was arrested for.
Et même les accusations yo, donc tout ça, toute preuve montré que il était fait agression, il était baiko.
I believe it's certainly reasonable to argue that were not for her ability to get his hands off of her neck.
Et n'a pas voulu nous faire que tribunal la connaît que si c'est pas possibilité que il était fait pour lui goumen retirer main sous cou li.
That Mr. Thermostal could be facing a charge of strangulation.
Et que M. Temastal était capable même mettre accusation que il était essayé d'étrangler.
All right, Mr. Thermostal.
Yes, ma'am.
I don't want to hear about the facts of the case.
Monsieur Temastal, donc nous pas attendre aucun fait sur qui Jean a été passé.
The state has recommended a bond of $10,000 and pretrial release with electronic monitoring.
Donc l'État donc you mettez devant $10,000 pour payer comme bonne caution dette pour yo capable laguer avant que yo tribunal et laguer avec un GPS sous pied ou bracelet sous pied.
Do you have $10,000?
Est-ce que $10,000?
No, I don't have $10,000, ma'am.
All right, do you need the interpreter or you do not need the interpreter?
Est-ce qu'on a besoin d'interprète là ou non?
Donc, I besoin, pas $10,000.
Yes, I'll need him. I don't have $10,000.
Okay,
I don't have
but
$10,000.
you can't. You need to use the interpreter, okay?
Ou besoin servir avec interprète là.
All right.
Okay.
What do you have?
Donc qui ça que vous gagnez?
Actuellement, là, j'ai mortgage, je paye, je tout bail mortgage, ça comme je dépense à mortgage, je paye avec. Même moyen, pas moyen, mamselle.
So right now, actually, what I'm paying, the money I have is going straight to the mortgage. That's all I have. My money's going to my mortgage, and I never even touched it.
What did I tell you?
Donc qui ça que le défect dit là?
Okay. Okay.
See, Mr. Thermostal, that gives me the impression that you have a hard time listening and paying attention to what you're told.
So donc le fait que ou pas écouter, ça a l'impression que ou pas gagne habitude tant des monde les monde parler ensemble avec.
Okay, sorry.
Okay, sorry.
Where do you work?
Qui côté au travail?
I work for Publix.
I work for Publix.
How much do you make?
Combien que vous faites?
I make $16, so I have a mortgage, light bill, insurance bill, loan, all that.
So I make $16. I have a mortgage, light bill, insurance bill, more, all that.
Okay, and Miss Thermostal, you have children in common with Mr. Thermostal?
Madame Thermostal, ou gen ti moun ensemble avec lui? Yes.
How many?
Combien ti moun nou gen ensemble? 2.
How long have you been living here, Mr. Thermostal, in Broward County?
Donc, pour combien d'années que vous êtes
like-
la Broward County, Monsieur Thermostal?
That's probably like 7 years.
All right. All right. I'm gonna set the bond at $10,000.
M'a mette bon nan, comme pour payer pour yo la $10,000.
I'm gonna order Mr. Thermostal be put on pretrial release with electronic monitoring.
Y a pas mette que yo capable la yo surveiller comme ça avec un GPS sous pied yo.
I'm gonna order Mr. Thermostal that you have absolutely no contact with Daphne Thermostal Monsu. Understood?
Et n'a pas
Oui.
mette l'ordre pour pas gen pour pas gen contact ensemble avec Daphne Mondessor monsieur.
You are not to contact her directly or indirectly.
Ou pas doit gen contact avec lui directement soit indirectement.
Okay.
Okay.
What are we gonna do with the children when they
Well,
need contact?
Your Honor, I was going to be asking, considering this allegedly occurred while they were having a custody transfer, I'm going to be asking for, until further order of the court, that there just not be any contact with her.
Okay.
And I guess that'll mean they won't have contact with the children for the time being.
So, donc, nous demandons qui ça qu'on a fait avec Timoun. Bon, puisque ça t'est passé pendant que Timoun était au courant, il présent de ça. Donc, nous demandons que pour le moment, nous pas de contact ensemble avec lui et ça veut dire qu'on va pas de contact avec Timoun tout.
All right. And you're, Mr. Thermostal, you cannot contact her family to relay any messages to her. Understood?
Et faire sûr
Non.
que ou pas contacter famille pour passer aucun message par lui.
Do you understand?
Est-ce que vous comprenez?
You understand, yeah?
Okay, very good. Thank you very much, sir. Ms. Thermostal, good luck to you.
Merci en pile, Madame Thermostal. Bon chance à vous-même.
All right. Would you make an announcement, sir?
Est-ce que y a aucun autre monde là qui besoin de service interprète là en créole?
Anybody need the assistance of the Creole interpreter at the main jail?
One more.
What's his name?
Kingsley Crescent.
Kingsley
Kingsley Crescent.
Kingsley.
Yeah.
One more, Judge. Crescent.
What?
I think it's Kingsley
Cursing?
Crescent.
Cursing? Oh, that's the one that I was looking
Yeah. Right. Anything about those, the three?
These are the slower ones. All right, Kingsley Crusade. I got it.
Judge, he can understand English too, but
He can?
He can, yeah.
So he's trying to get out of there quicker by using this Creole interpreter?
No, I wouldn't say that, Judge. He's more comfortable with Creole than he is with English, but he
All
can
right, well-
communicate in English.
All right, we won't deprive Mr. Crusade of the assistance of understanding the proceedings a little bit better.
So, donc, nous pas dépriver pour le fait que vous avez une chance pour tenter procédure légale ça y est bien.
All right, Mr. Crusade, this is a magistrate hearing. As you heard me previously explain to the gentleman, it is non-adversarial.
So, donc, ça c'est un cas tribunal magistrat, ça veut dire que ça c'est un cas côté nous pas aucun adversaire là-dedans.
Mr. Crusade, you're being charged with false imprisonment of an adult and toucher strike battery as a dating violence.
So, donc, l'accusation que yo lagué sous c'est que faux emprisonnement et il est fini donc vous frappé par coup à un monde.
I find probable cause for the capias, that is the warrant that was signed by Judge Yuson.
Donc, et lui, ouais, que y a une bonne raison pour yo laguer un mandat judiciaire ou même, un mandat qui était fait par le juge Husson.
And as to count 2, the bond by Judge Yuson was set at $1,000. I am not going to disturb that bond.
Et juge Husson te dit pour yo laguer pour payer $1,000 caution dette, papier dette, et il dit ouais que ça c'est un bon genre pour payer pour yo laguer.
As to count 1, false imprisonment of an adult, I will, unless there's any probable cause argument, I find probable cause.
Donc, et quand pour première accusation, donc il voit que il y a bon genre raison pour accusation le fait que tu as un coup on frappe qui t'est fait.
All right, so I find probable cause as to count 1, false imprisonment. As to the bond amount, that is what we'll go ahead and discuss.
So donc kounya là donc quand pour première accusation, il voit que il y a bon genre raison pour ça et kounya là nous va parler sur affaire cob pour payer pour laguer.
Mr. Afzal, do you want an opportunity to inquire of your...
Judge, I did have an opportunity. I'll just go ahead and tell the court what he told me. He's been arrested. He currently lives in Miami in an efficiency.
So donc pour le moment donc m'était parlé ensemble avec lui et il t'a dit moi qui ça qui passé dans la ville que kounya là actuellement la prêté Miami dans yon petit chambre.
He pays $550 a month towards rent.
Il paye $550 par mois pour loyer.
He used to live in Broward County. He was residing here for 2 years.
Et il était connecté Broward County et il était là.
Total of 11 years in South Florida.
Et il y a n'importe 11 ans depuis la vivre ici là dans Florida Sud.
He is gainfully employed. He works as a chef at, I believe the name of the restaurant is Iro Japanese Restaurant in North Miami Beach, where he's been.
Et il travaille en tant que chef dans restaurant japonais qui est le Heroes là.
Where he's been gainfully employed for 9 years.
Il a travaillé là-bas pendant 9 ans.
He makes about $1,500 a month working there.
Et il fait à peu près $15 par mois pendant la travail là-bas.
What he told me is he has about $400 to $500 saved up, and he could use that towards bond. I would ask the court to set a $3,500 bond on count 1.
So donc il dit que il y a n'importe $400 à $600 que il serré, il est capable de servir avec ça comme papier dette là et la monnaie tribunal là pour le descendre dette là à $3,500.
All right, so what are you, all right, state?
Your Honor, Mr. Kersain has no criminal record. Based on the allegations, the state is going to be requesting a $2,500 bond on one.
So donc puisque M. Christian n'a pas eu aucune autre activité criminelle dans le passé et donc n'a demandé que avec accusation ça que il venu avec en $2,500 papier bond.
All right, Mr. Kersaint,
Donc M. Christian.
in addition to the monetary bond that I'll go ahead and be placing in a little bit, I'm going to order you, Mr. Kersaint, to have absolutely no contact with the victim in this case, Marlenda Vilsaint. Understood?
So donc en plus de ça, donc on a demandé pour pas aucun contact ensemble avec la victime Marlenda Vilsaint.
Indirectly or directly. That means you cannot have people call her on your behalf or anything like that.
So donc quitte c'est en façon directe ou indirecte ou pas doit gagner même monde passer message soit relé pour vous.
Yes.
You understand that violating this order may subject you to additional criminal charges.
So donc si vous t'a violé mandat ça l'autre ça que vous passé, vous capable mettre plus accusation légale sur vous.
You understand that?
Est-ce que vous comprenez ça?
Yeah.
Okay.
Yeah.
All right. So as to count 1, the bond will be set at $2,500.
So donc pour première accusation, donc il a mis pour payer un bond de $2,500.
And good luck to you, sir.
Et bonne chance à vous-même.
All right. Would you like to make an announcement?
Donc est-ce que il y a aucun autre monde qui besoin de service interprète là en créole?
Anybody else need the Creole interpreter? No?
No, Judge.
All right, thank you. Paul Ryan, anybody at Paul Ryan need this Creole interpreter?
No, Judge.
Thank you very much. Anybody in North Broward?
No, Your Honor.
Thank you very much. All right, sir, Creole interpreter.
Your Honor, would you mind signing?
Yeah, I'll sign. All right, let's go with Karen Zinzer.
Your Honor, after this case, if it please the court, I have a detective present. I'm going to,
Okay.
3 co-defendants, if we could call it out of turn. Thank you.
All right, Ms. Sinzer, welcome, good morning. You're being charged with 2 counts of violation of community control and 2 separate felony cases. Those warrants, I find probable cause for those warrants. You're being held no bond. I can't disturb those warrants nor the bond in that case. The good news is that you're gonna go see your division judge on April 18, 2017. Good luck to you, Ms. Sinzer.
Thanks.
All right, what's the name?
Rakeem James, Artis Wilson, and Maurice Jackson.
Are these the
Judge, unfortunately,
juveniles?
because of
The-
security issues, they can't bring them all 3. They have to be separated. I have Mr. James is here, I believe, and he's represented by private counsel. He doesn't remember the name of his attorney. They just hired him last night. They have to be brought here separately.
Okay. Who's Mr. James?
Yes, ma'am.
Okay, thank you for responding. Who's your attorney?
I don't know his name.
All right, so do you want the assistance of the public defender's office to help you out?
Yes, ma'am.
Well, Judge, if he's represented by private counsel,
I don't
Did
think
they
he
put-
knows. I mean, Mr. James, do you want to wait for your private attorney to contact your family? I don't know how to contact.
That's
What's
the
his,
thing. If you
Judge,
don't
I
think-
can get his mother's number. Maybe Mr. Reedy could call him from the court phone and find out who the lawyer is.
Okay, that'll work. As far as the detective, hello, how are you?
Hello, Your Honor. How are you this morning?
I'm doing very well, thank you for asking. As far as the detective that we have here present, you want to just take testimony from him regarding these 3 cases and then
If it's okay with the court.
have
sure.
him leave? Because it's not adversarial. I'm not going to allow the public defender, this is just for,
Your Honor, we'd appreciate that, so Detective Cook can testify.
What would you like?
We're gonna testify.
Oh, that's fine.
and then you can go and then, because they can't be all brought up at the same time, so.
And we'll just go through it one time and that's it?
Right.
Okay, perfect.
All right, would you please raise your right hand, sir? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
All right, you may put your hand down.
Detective, please state your name for the record.
My name is Detective John A. Cook. I am employed with the City of Hollywood Police Department, where I have been for 19 years.
And your current rank?
I am a detective, and I'm assigned to the Violent Crimes Unit.
And how long have you been a detective?
I've been a detective for 4 years, 2 years in burglary, and I've been in the Violent Crimes Unit for 2 years.
Okay, and did you investigate an alleged robbery firearm and home invasion with a firearm that occurred on March 27th of this year in Hollywood?
Yes, I did.
And as a result of this investigation, did you charge Rakeem Jones, Maurice Jackson, and Artis Wilson? Rakeem James and Artis
Judge,
Wilson.
I don't mean to interrupt, but we have 2 defendants who are not present. We have possible private counsel for Mr. Jackson, who was also not present. And I really think that all these parties should be present one way or another if the court is going to be receiving testimony regarding probable cause and possibly with an eye toward holding these juveniles without bond. I think that's where the state's going with this.
Well, Your Honor, as far as the issue with the attorney, that's one thing. As far as testifying, each one being present, certainly Your Honor can take testimony and take that in consideration with regards to each defendant. It's not the detective's fault. There's nothing we can do about the jail not being able, for security reasons, to keep them separate.
But we've also, it's for security reasons. I can't tell the jail what to do and they can't tell me what to do. That's just the separation of powers, how it works. If the jail has concerns over their safety and over the safety of others and has to separate them, I'll defer to them since they obviously know how to manage a jail a little bit better than I do. A lot better than I do. So, but Mr. Reedy is right. I mean, I was trying to expedite, but how would they otherwise hear the testimony or be made aware of what occurred on that day? So although I tried to save you the time so that you can go back, we're gonna have to wait. At the very least, to have all 3 of them here. And you're gonna have to try to remember what you said and repeat. what you
Yeah,
said.
you just wanted me to say it 3 times?
Eventually, yes.
Well, I can do it once with him here, and then you can bring the next. I know exactly what I did and what they did. So
No, I
can say
understand.
once with him, once with the next
Well,
one.
the problem is also he's
The
saying
other
he has
problem
an
is that they may
attorney.
have private counsel, or rather, Mr. James may have private counsel. So we just need to give them an opportunity to see about that. So if you could, Detective, just momentarily have a seat.
Sure.
And we'll try to get this, I'm sorry.
It's okay. Thank you, Judge.
All right. Just. All right, let's go ahead and have Mr. James have a seat. Mr. Afzal, let's try to get through some of this docket while Mr. Reedy, I guess, tries to find out if Mr. James does in fact have private counsel. Let's get Suxshili Torres.
She's here at the main judge. She's claiming that the warrant's not her. That Sushili Torres is her cousin, and that's not her name.
Well, then she needs to go ahead and compare those fingerprints. The jail needs to compare those fingerprints. She got arrested with it. I mean, she can go to the state's office, the state not me unit. As far as the capuses, Ms. Torres is being held on 5 counts. She's got count 1 is a capias for a misdemeanor traffic criminal charge. The bond is set at $250. I'm not disturbing that. I find probable cause for that count. Count 2 is a capias for a traffic misdemeanor charge. The bond is set at $500. I cannot and will not disturb that. That was set by the division judge. Count 3 is a capias for a misdemeanor charge. The bond was set at $500. I am not and will not disturb that bond. Count 4 is a capias for a misdemeanor charge. The bond was set at $250. I am not disturbing that. And she's also being held on an out-of-county hold. So, which I can't touch, and obviously she's being held no bond on that. On April 20th, 2017, Ms. Torres, you'll have an opportunity to go before the division judge and you can re-raise those issues, but I can't just I can't, you need to contact the state attorney's office.
Judge, the reason I mentioned that is that I'm informing confinement status now that she's claiming it's not her.
Okay.
They can maybe compare the fingerprints to determine that maybe she can be released earlier if in fact it's not.
If it is in fact not her, then she's obviously going to get released because you can't hold somebody that is not the person that is being held.
My understanding is she tells the jail.
Completely understand, but they would have to compare the fingerprints, so I'm putting them on.
Right, that's fine. But if it is her, then it is what it is.
Right.
All right? Thank you. Greta Binns.
Date of birth.
Main jail.
Welcome, Ms. Binns. You're being held on a violation of probation on a felony case. You're being held no bond on that. I find probable cause for the BOP. And I'm not disturbing the no bond. I cannot disturb the no bond. Good thing is that you're going to go see your division judge on April 18, 2017. Good luck to you, Ms. Binns. Jacqueline Berrio. North Broward.
That's North Broward, Your Honor.
Thank you very much, sir. All right, Ms. Berrio, you're being held on 2 capiases. Count 1 is a capias for a misdemeanor case. The bond was set at $250. I'm not disturbing that. I find the probable cause for the capias. And you're also being held on a capias for a felony signed by Judge Porth, and you're being held no bond on that, ma'am. Ms. Berrio, I cannot disturb those bonds. Good luck to you. Take care.
Thank you.
You're welcome, ma'am. Jennifer Siasia?
Oh man, that's the reset. That's the reset, Your Honor. We had her here, but she couldn't wait. That's North Broward for you.
Well, Your Honor, it's a VOP. No bond. There's really nothing the court can do. I mean,
Well, I guess we'll just reset her to tomorrow.
It's the same thing.
Tomorrow is the 14th. All right, Christina Collins. Thank you, Deputy. Christina Collins?
She's here in North Broward, Your Honor.
Yep, thank you.
Have a seat, one.
All right, welcome, Ms. Collins. You're charged with 4 counts. Count 1 is driving while license suspended as the first offense. Count 2 is possession of alprazolam, also known as Xanax. Count 2 is possession of heroin, and count 4 is drug paraphernalia possession and or use. Is there any probable cause argument?
Well, I know that Ms. Collins indicated to the authorities that she had a prescription for the Xanax.
Traded in for a higher dosage,
Well,
allegedly.
Allegedly. But that would be the only probable cause argument that I have. And as I told her, ultimately, if she does have the prescription, it's the right prescription, the charge could be dismissed. I spoke with her mom. Her mom is going to bond her out.
Okay.
She was asking if the bond could be reduced a little bit to maybe a total of $1,200.
All right. Mr. Linder, any priors?
No, Judge.
All right. So I will leave count one's bond. I find probable cause for all 4 counts. And I will leave count 1 at the $100. I will reduce count 2 to $500. I will reduce count 3 to $500. And I will leave count 4 at $100. Good luck to you, Ms. Collins. $1,200 total.
Thank you, Judge.
Thank you, Judge.
You're welcome. Melissa Connors.
Yes, ma'am.
All right, Ms. Connors, welcome. All right, Ms. Connors, your count 1, you have 3 counts. You're charged with count 1 is grand theft as a felony. Count 2 is illegal use of a credit card, dealing in others. And count 3 is illegal use of a credit card more than 2 times in a 6-month something, goods or something. I have an issue
Okay.
with, I have an issue with the grand theft. Mr. Reedy?
Yes, ma'am.
No, not you. You have an attorney that's.
Actually, Judge, is looking it over, I don't even have the second page of the probable cause. Oh, here it is. Yes, that's correct.
It's not that fundamental, but.
Right.
Other than her statement, Mr. Linder, you don't have anything else as far as the grand theft is concerned. You have the. You only have her statements.
All right, we can come back, Judge. That's fine. I'll ask for 24 hours.
All right, 24 hours to perfect. In the meantime, did you verify her? Yes. Did she have any priors?
Yes. In 2010 and 2009 in Palm Beach, she failed to appear in court. 2001 Baker County introducing contraband into a correction institution. 2000 in Palm Beach grand theft. And let's see if there's anything else. Theft 2014 out of Palm Beach. She went through diversion 2015 in Palm Beach for theft. End of record.
Contact Deputy Groves, Deputy Fain. Maintenance and medical. Contact Deputy Fain, Deputy Groves.
All right, I don't know that I want to pretrial release her. At the very least, I'll leave the bonds at $1,000 and allow the state 24 hours to perfect on all 3 counts, actually. Because I don't have the illegal use of a credit card. She had to have use. Right? And there's
That's
no
right.
information.
She's keeping the bonds where they are 24 hours.
All right, so we'll leave the bonds. And all right, Ms. Connors, I'm leaving the bonds. If you're able to set the bond at 3,000, the bonds I'm not disturbing right now, but I'm giving the state 24 hours to perfect their probable cause because at this time they need some time for that.
Meaning, so if I could come up with the $3,000 bond, then I could be released. If not, I just stay here until 24 hours, you said, until they come up with the evidence?
Correct. Or it's not evidence that they're going to come up with. They're going to come up with a sworn probable cause testimony regarding those elements that are missing for those 3 charges, okay? But yes, you're right.
Okay.
If in the meantime you're able to come up with the $3,000, great. And right.
Okay, there was one question. They said with the pretrial, I understand I'm not able to do that, but did they verify my address? Was my address okay and everything?
Yes,
did they say it was?
Yes, they did. Yes,
okay.
they did. All
That's
right.
one thing I wanted. Thank you very much, ma'am.
You're very
Have
welcome.
a good
Take
day.
care, ma'am. You too. Linda Marchesalt.
It's going to be a medical reset, Your Honor.
All right, we'll we'll reset her to tomorrow. Jessica Pinedo.
Come on, Panero. Yeah, I'm sorry. Merchant is a medical reset.
Okay.
Panero seems nice.
All right, Miss Pinero, how are you doing? All right, Miss Pinero, you have 4 counts. You have 4 separate violations of probation. Count 1 is a violation of probation for 1 felony case. Count 2 is a violation of probation for another felony case. And count 3 is a violation of probation for another felony case. And count 4 is a violation of probation for another felony case. I find probable cause for all VOPs, and you're being held no bond on all of those. I cannot disturb those as they were signed by that division judge. And the good thing is that you're going to go see your division judge on April 24, 2017. Good luck to you, ma'am. Thank you. Kelton Mobley, main jail. All right, Mr. Mobley. All right, Mr. Mobley, you're being held on 2 counts. Count 1 is a capias for a misdemeanor, a traffic criminal misdemeanor. The bond was set at $1,000. I find probable cause for that capias signed by the division judge, and I'm not disturbing the $1,000 bond. Count 2 is a violation of probation for a misdemeanor charge. I find probable cause for that VOP, and I'm not touching the $2,000 bond that division judge set because I cannot. Good luck to you, sir. Felix Macedo, main jail. All right, Mr. Macedo, you have 7 counts. Count 1 is drug paraphernalia possession and or use. Count 2 is driving while license suspended. Count 3 is possession of open container in a motor vehicle, which is not, these are not for magistrate, right? Because those were no charged? Right.
Yeah, yes, Judge.
All right, so that count 4 is drug paraphernalia possession or use. Count 5 is drug paraphernalia possession or use. Count 6 is drug paraphernalia possession and or use. And count 7 is drug paraphernalia possession and or use, which I have an issue with all paraphernalia counts because there was no. Am I right, Mr. Reed?
Yes, you are, Judge.
So.
Well,
it also seems to be 1 possession of drug paraphernalia charge to me. I mean, it's all one.
Well, they have 3 glass pipes and 2 marijuana grinders, but there's no field test positive as to whether they were, in fact, they had any, there's nothing. So.
Judge, will the court ROR counts 4 through 7? He said he can afford a $100 bond.
State.
On the count.
One moment, Judge.
What?
We can hear you.
That's fine, Judge.
All right, do you still want the time to perfect? Just like, no? All right, count 1, I'll leave at $100. Count 4 will be an ROR. Count 5 will be an ROR. Count 6 will be an ROR. And count 7 will be ROR as well. Now, I'm not finding probable cause, so what does that do? Procedurally.
Well, you found PC for DWLS, correct?
No, that's a no charge. It says no
No,
charge.
it's that's a charge. It's not a no charge.
It's a charge. It doesn't require a bond.
Well, it doesn't have a bond because the other charges had a bond. Your Honor can set a bond on it. Your Honor can ROR him. It's up to the court. But it's not a no charge. It says no charge because the bond was put on the paraphernalia. It's.
I find probable cause for the driving while license suspended.
Yes, that's exactly what I was doing. Yes, ma'am.
Nope.
Count 2.
No, well, yeah, I get, you know what? I'll ROR on count 1 and I'll set a bond at $100 for count 2. The driving while license suspended. All right, thank you, sir. Good luck. Brandon Haynes.
That's North Broward, Your Honor.
All right. How are you, Mr. Haynes?
Yes.
Mr. Haynes, you are being held on a capias for a municipal ordinance case, specifically as it relates to soliciting in public without a permit. You're being held $50 bond.
Okay.
This is Lauderdale Lakes.
If he puts a bond on that.
Do you have $50?
No. We won't have it either. If they post bond, they don't give it to us. They
Okay.
send it through other.
All right, Mr. Haynes, do you want to take care of this case today?
Yes.
Is that a yes?
Yes.
Okay. Mr. Haynes, I need you to speak up a little bit, okay? All right.
Okay.
Mr. Haynes, would you please raise your right hand, sir? Yeah. Do you swear affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, you may put your hand down, sir. Mr. Haynes, are you under the influence of any alcohol, medication, or drugs?
No.
Have you ever been treated for a mental illness, Mr. Haynes?
No.
All right, can you read, write, and understand English?
Yes.
All right, Mr. Haynes, are you on probation or parole anywhere in the world?
No.
Do you have other pending cases?
I don't think so. No.
Okay. All right, Mr. Haynes, you understand that if you resolve your case today, that may affect those pending cases?
Yes.
Okay. And you still want to resolve your case today?
Yes.
Okay. Mr. Haynes, you understand about that by taking this plea, if you're not a U.S. citizen, this will subject you to deportation. You understand that?
Yes.
All right, Mr. Haynes, and you don't want to exercise your right to go to trial?
Yes.
You do not,
yeah.
or do?
No. No. No.
Okay, you do not want to take it to trial.
I can't really. Nah. I don't know. No.
Okay. All right, Mr. Haynes, as to the charge of soliciting in public without a permit, how do you plead, guilty or no contest?
No contest.
All right, I accept your plea. I find that you're freely, voluntarily, and intelligently waiving your rights. I find that you're competent, coherent, alert, and I find that you know and entering this plea and understand the nature of the charges and the consequences of this plea. I will sentence you as a result of that to a withhold of adjudication and court costs, Mr. Haynes. All right, good luck to you, sir. You're going to get released today at some point.
Okay.
Elijah Chang.
Judge, his bond may have been posted.
Elijah Chang's bond may have been posted?
Andrew Vernon?
Okay. Yeah, but then I would, if his bond is posted and it's just a matter of time before he gets released, then if they're going to make an argument to increase that bond that was already posted would be moot. Madam Jail. His bond has not been posted. Okay. Mr. Chang, you have two counts. Count one is possession of cannabis 20 grams or less. And count two is resisting an officer without violence. Resisting an officer or obstruction without violence. Any probable cause arguments as to both counts?
No, Your Honor.
All right, I find probable cause as to both counts. As to the bond, any, Mr. Upsall?
Judge, didn't they say his bond was posted?
No, they did not.
Judge, he said, when speaking with him, he said his family put the money down to post his bond, but in light of the charges of misdemeanor possession of marijuana, will the court consider RORing? He does have family down here.
Any priors, Mr.?
Went through pretrial last year in Palm Beach for the same charge.
Was he successful?
Well, I guess he was successful in that program. Was the program successful? That's another question since he's here today.
Oh, was he successful in completing the program?
It looks like he completed it. Yeah.
Okay. And that's it? There's no more priors?
There was a domestic violence arrest that was dropped though.
He has medical issues too, Judge, that I don't want to say on the record because everything's being streamed online.
Right. All right, I'm gonna leave the bond at $100 on count one, and I'll ROR him on count two. I'm not going to ROR him straight out. Okay? Breon Papa? Breon Papa?
Present at the main.
All right, Mr. Papa, you're charged with 4 counts. Mr. Papa, your count 1 is leaving the scene of a crash involving damage to property. Count 2 is driving while license suspended as a second offense. Count 3 is a violation of probation for a misdemeanor charge, which I find probable cause for, and I'm not disturbing the no bond on that case because I cannot. And count 4 is a capias on a traffic criminal case, find probable cause for that capias, and the bond was set at $500 by that division judge, which I'm not disturbing as well. As to leaving the scene of an accident and driving while license suspended, any probable cause argument?
It doesn't appear to be, Judge. Unfortunately, he's not going anywhere, so otherwise I'd point out that he did return to the scene voluntarily and admit that he did not have a driver's license and that he was the driver of the vehicle. It seems like he cooperated with police, but he's being held on a driving on a suspended license charge, violation of probation.
All right,
so.
Mr. Linder, I'm contemplating RORing him on those 2 new charges.
Well, I
because-
mean, Your Honor, considering he's on probation for DWLS, he's got another open DWLS he doesn't show up on, and he's driving again, and this time getting in an accident and leaving the scene. I mean, clearly there's a concern about him showing up in court. I don't really see any reason to mitigate and give him an ROR.
All right, I'll leave count 2 at
Is it?
$100.
Is that it?
No.
I'm not gonna put a bond on count 1. Thank you.
But he's coming on.
Santiago Alvarez, North Broward.
North Broward.
All right, Mr. Alvarez, how are you doing, sir?
I'm doing pretty good. How are you, ma'am?
I'm doing very well. Thank you for asking. Mr. Alvarez,
You're
you're being charged with a capias on a misdemeanor case. I find probable cause for that capias that was signed by that division judge for your case involving possession of cannabis. The bond was set at $100 by that division judge. I'm not disturbing that.
Your Honor?
Good luck, yes.
Well, just so you know, he has other priors. If he wants, the state's offer would be a withholding court costs, judicial notice of time served, if he's interested in resolving it.
Mr. Alvarez, what the state is offering you is if you want to resolve
assuming
the
the court's
case today, you have the absolute option of posting a $100 bond. If you don't want to do that and you want to resolve the case today, the offer would be a withheld adjudication. That means that you would not have a conviction on your record for this charge, and it would not suspend your driver's license for 2 years.
Well, my driver's license is already suspended. This is my first drug charge, so I was wondering if I could get ROR. I've never had a drug charge in my life.
Would that be possible, Judge?
He's here because he can show up in court.
I can't, it's a capias.
Capias. The judge isn't willing to do that. It's a $100 bond. Santiago, do you have $100?
I don't. I'm homeless right now.
All right, well, tell me what you want to do, brother.
I just want to take care of it today and go home.
What happened to your hand?
I actually was in the middle of the police officer broke my thumb arresting me.
All right. Okay, do you want to resolve it? To let us know.
Yes, sir.
All right, Mr. Alvarez Santiago, would you please raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may put your hand down, sir. Mr. Alvarez, are you under the influence of any alcohol, medication, or drugs right now?
No, ma'am.
All right, have you ever been treated for a mental illness?
No, ma'am.
Can you read, write, and understand English?
Yes, ma'am.
All right, so you understand everything that's going on here today, Mr. Alvarez?
Yes, ma'am, I do.
All right, Mr. Alvarez, the state has made you an offer for this charge of a withhold of adjudication and court costs, and you wish to take that offer?
Yes, ma'am.
All right, Mr. Alvarez, are you on probation or parole anywhere in the world?
No, ma'am.
Do you have any pending cases?
No, ma'am.
All right. Mr. Alvarez, you've had an opportunity to talk to Mr. Reedy, who gave you some legal advice. Are you satisfied with his advice?
Yes, ma'am.
All right, very good. Mr. Alvarez, and you don't want to take your case to trial?
No, ma'am.
All right. Mr. Alvarez, as you understand that if you're not a U.S. citizen, taking this plea will subject you to deportation. You understand that?
Yes, ma'am.
Okay. As to the charge of possession of cannabis, 20 grams or less, how do you plead, Mr. Alvarez? Guilty or no contest?
No contest.
All right, I accept your plea. I find that you're fully voluntarily intelligent. We have your rights. I find that you're competent, coherent, alert, and I find that you know only entering this plea and understand that each of the charges is the consequence of the plea. Counsel, you stipulate to a factual basis?
Yes, Your Honor.
All right, for purposes of the plea, upon the stipulation, I sentence you to the negotiated offer of a withhold of adjudication and court costs. I'm going to give you 3 months to pay those court costs. You need more time?
No, ma'am, I should be okay with that.
All right, and I'll allow for partial payments. If you need more time, just let me know.
All right, the only thing I ask is just some time to get back my hand. You know, I work with my hands, so I just got this 24 hours ago.
Well, you're gonna be released today, so hopefully you'll be able to get a better setup
Perfect.
for your hand. All right?
Thank you. I appreciate you.
You're very welcome.
Good
sir.
luck, man.
Take care.
Hey, you too. Bye bye.
All right, what are we doing on the juvenile cases? Mr. Reedy, did you get a hold of?
I spoke with one of the mothers. I believe it was.
James's mother?
No, actually, it was.
Oh, James's mother's right here.
Oh, okay.
Oh, good.
Maybe-
James. Rakeem James. How are you, Mom? Could be better? Could be better? All right, Mr. James, your mom is here. Mom, have you hired a private attorney for?
No, not yet.
Okay, so because Mr. James had informed us that you had hired a private attorney, and that.
Trying to look for one.
Okay.
I actually went to the public defender's office this morning and was conversating. So.
Okay, so Mr. James, good news. I guess good news and bad news, a little bit of both. Your mom has been talking to the public defender's office, so you'll, hopefully, Mom, you want to have the public defender's office represent Mr. James?
Yes.
Okay, very good. So the public defender's office I appoint the public defender's office to represent Mr. James in this matter. We also have Detective Cook present, who is going to discuss this case. Mom, I will give you an opportunity to talk to me about his possible release conditions once probable cause is found, okay?
Okay.
All right, so let's hear from Mr. James is charged with 2 counts. Count 1 is home invasion with a firearm or other deadly weapon, and count 2 is robbery with a firearm.
And, Your Honor, just to advise the court, the state is seeking, Mr. James is charged with 2 punishable by life offenses. The state is seeking no bond holds on both counts. And I've had Detective Cook come in to provide some additional information. Just the state is going to be seeking a finding of proof evident or presumption great for first appearance purposes only.
Is that an Arthur hearing?
Your Honor, the state's position.
That's what we're going to be asking for.
Your Honor, the state's position is, under the rules of criminal procedure, the court can make a finding of proof evident or presumption great and not hold an Arthur hearing. Your Honor, it is not, just because there's a finding of proof evident or presumption great does not make it an Arthur hearing. In fact, it's a first appearance. It can't be an Arthur hearing. As you've stated numerous times, today's a non-adversarial hearing, which would go against it being an Arthur hearing where the defense can provide evidence to try to refute proof evident or presumption great. Just because
You're asking me to make a finding of proof, grade, presumption, whatever, proof.
But Judge,
Proof evident, presumption great.
Your Honor, let me put it this way. Could we agree that in division on a DUI, the defense could file a probable cause motion to argue that there wasn't an evidentiary hearing, that there wasn't probable cause, and that any evidence obtained after the arrest could be
Wouldn't
thrown
you
out?
have to file a motion for pretrial detention?
No, Your Honor. There's no.
Yes.
Actually, Mr. Reedy has said multiple times that the state has 2 options. He may not like the option that the state chooses, but he has said multiple times that the state can seek a finding of proof evident or presumption great to hold a defendant no bond, Your Honor.
Pursuant to an Arthur hearing. Or they can follow the rules of criminal procedure and file a motion for pretrial detention ahead of time, in which case the only obligation on the court this morning would be to make a determination of probable cause. You wouldn't be forced to be in the untenable position of making a finding of proof evident presumption great. In addition to that, the case would then be reset for 3 days according to the rules of criminal procedure so a proper Arthur hearing could be conducted.
No, Your Honor, it's not. I don't even know where to begin. Your Honor, the state is following the rules of criminal procedure, even asking the court to make a finding of proof evident presumption great. Your Honor, I can refer the court to Rule 3. I'll provide you with mine, Your Honor. I just want to get the rules right. 3.130D and Rule 3.131A. 3.310D specifically states the procedure in which a defendant, in which the court will set pretrial release conditions, and it refers to 3.31A. 3.31A specifically says a defendant is entitled to pretrial release conditions unless charged with a capital or punishable by life offense and proof evident or presumption great is found. So 1, it is pursuant to the rules of criminal procedure. 2, clearly the Supreme Court does not find it untenable, or they wouldn't be putting in that language. 3, and the reason, Your Honor, I was bringing up an example of an evidentiary probable cause hearing in front of an assigned judge, just because the burden of proof is proof evident or presumption great, that does not in and of itself make it an Arthur hearing. What makes an Arthur hearing is that it's a 2-part hearing. 1, where the state must satisfy proof evident or presumption great. 2, if the state does, then the defense can still seek a bond, but it's an evidentiary adversarial hearing, which it cannot be at a first appearance. Now, Your Honor, the state concedes, even if Your Honor finds proof evident or presumption great today and holds the defendant no bond, the defense has an absolute right to still seek an Arthur hearing in division.
If there is a change in circumstances,
No,
once I've
no,
made that finding,
no, Your Honor,
the division judge is stuck with it.
No, Your Honor, if I may, Your Honor, as you stated today, the defense cannot, since it's non-adversarial, the defense cannot present evidence to refute PC. But we would agree at an Arthur hearing, let's say hypothetically the defense had an alibi witness. Certainly they could present an alibi witness at an Arthur hearing to refute a finding of proof evident or presumption great.
Right.
So certainly the defense can seek an evidentiary Arthur hearing. Just like the court can find no PC today on a battery, DUI, possession of cocaine, and the defense can seek a motion for probable cause at a later date. And if the court finds, based on the evidentiary hearing, adversarial evidentiary hearing, that probable cause doesn't exist, the court can throw out any evidence that was obtained after the arrest. The burden doesn't dictate what type of hearing it is. This is a first appearance hearing. All I'm asking is, pursuant to the plain language of the rule, is the court hear the evidence to determine if the state satisfies its burden. I'm conceding, the state is conceding, the defense has, no matter what, even if you hold no bond, the defense retains the right to seek an evidentiary adversarial Arthur hearing. And because your finding is only based on evidence provided by the state, the defense can seek, and is entitled to seek, a new proof evident or presumption great review based on an adversarial and evidentiary basis.
Okay. Anything else regarding this issue, regarding the procedural issue?
Yes, Judge, just to make it our position very clear, we are asking the court to conduct an Arthur hearing pursuant to the Florida Constitution in State v. Arthur. We are also asking the court to set bond in Mr. James' case. This court cannot possibly make a finding of proof evident presumption great based on an arrest affidavit, and I know you haven't heard all the testimony from the detective yet, and I'm sure you will shortly. But our position is that even though with the testimony of the detective and the arrest affidavit that I've reviewed, that is still not enough for this court to make the very high finding of proof evident presumption great, which is higher than proof beyond a reasonable doubt. So we would ask this court to be looking towards setting a bond for Mr. James at this time.
If I could just say one thing in response, Your Honor.
One thing.
Thank you. And I can provide the court the case law. Brackett v. State, which is out of the 4th ECA, specifically says the state can rely upon affidavits at any bond hearing where there's a determination of proof evident or presumption great. So to say that the court can't rely upon affidavits, it's just not true.
All right. I am not, and I may be wrong, it is quite possible. I am not comfortable with, I'm not going to conduct the Arthur hearing at magistrate. In fact, I believe that that is being taken up by someone with a colleague of mine. So that's for sure out. I don't feel comfortable making a finding of proof evident presumption great and locking in a finding of that sort wherein, regardless of whether the defense counsel will have an opportunity to re-raise it, I don't feel comfortable with that, and absent a motion for pretrial detention from the state, I don't feel comfortable. Unfortunately, what that means is that Mr. James will be held no bond until there is an Arthur hearing in which defense will have an opportunity to present any and all mitigating circumstances and, information of that sort. So that being said,
Is Your Honor making that finding based on, and I imagine you've reviewed the affidavits already?
yes. Well, I'm not having the
No.
that is an Arthur. That is a procedural ruling that I'm making. Now we're going to move on to the probable cause.
Okay. Okay.
Right.
All right. Do you really need to go, right?
State, you have
Your
to
Honor,
take.
can we just have?
How do you want to do this, Judge? We've got 3 defendants, only one of whom is present. Foz, do we know if the other 2 defendants have hired private counsel?
I don't know.
Have they been in the courtroom at all yet today?
No.
That would be Mr. Wilson
They're here.
and Mr. Jackson?
They're in the cell. They have to. They're here at the main jail, but they haven't brought them to court yet.
Can they hear us?
No.
Well, we're just gonna have to do one at a time. There's no other way. Your Honor, I apologize. Could the detective could be excused for just a brief moment, please?
Sure.
Your Honor, if you want to move,
Yeah. Oh, okay. I was like, what's going? Okay.
Yeah.
We'll put Mr. James on a very, very brief recall. If we could just move on with the docket a little bit, try to get some of these cases done. Keith, necessary?
Paul Ryan.
All right, Mr. Necessary, how are ya?
Good, thank you, ma'am.
Mr. Necessary, you're being held on a capias on a felony charge, and I find probable cause for that capias. That was signed by that division judge for perhaps failing to appear, maybe?
no, it's Your Honor, it's an ad charge.
Yep, there it is. Yep. And the bond by that division judge was set at $1,000, sir, so I cannot and will not disperse that bond. But the good news is that you're gonna go see the judge on April 18th, okay?
Yes, ma'am, I got a question to ask you. The grand theft, what item is it and who's the victim?
You're gonna get some of that information when you go to court, hopefully on the 18th. The capias, that means the warrant was, that ad charge was signed by Judge Bailey, who did at the time presumably review all this information and found probable cause for it. So I'm kind of stuck with his decision regarding that. Okay?
Yes, ma'am, thank you.
All right, you're very welcome. But very good question, Mr. Necessary. Good luck to you.
Thank you.
Noah Muhammad, North Broward.
That's North Broward, Your Honor.
All right, Mr. Muhammad, you are being ad charged with 4 counts. Count 8 would be burglary unoccupied of a dwelling unarmed. Count 9 would be grand theft. Count 10 would be burglary occupied dwelling unarmed. Count 11 would be petty theft. Any probable cause argument?
Well, I would point out that the probable cause in reference to the stealing of the kayak, the officer writes that the defendant removed the kayak from the victim's home with the knowledge and/or permission of the victim.
Is that the grand theft?
It's the burglary dwelling.
And the grand theft, I'm assuming, because that would be the kayak?
It's $100 to $300. It's actually, I think, the petty theft count 11.
Okay. Okay. So as far as okay, that's the pet, and then it's the burglary unoccupied. This is very confusing. Oh, there's 2.
There are 2 probable cause affidavits, Judge.
Oh, okay.
One deals with a kayak and the other deals with, I think, some stolen watches.
From separate dates too. I'm sorry. I was like, that was a little confusing. Okay, so as to the occupied burg dwelling, and the petty theft, I cannot find.
Your Honor, can we reset this for the afternoon?
Sure. All right, Mr. Mohammed, we're going to come back
What?
at 1:30.
Just in case, yeah.
Get the detective to write in one more word and let me see.
Yep.
Without.
That's what I'm expecting.
Out. One word. Out. Okay, back on Mr. James, the detective. We're going to get these
Third
cases
time, Your
done
Honor.
today, I bet you.
You're gonna get this fixed.
All right, back on Mr. James. All right, so Mr. Linder,
Yes, Your Honor.
just to recap, I'm just proceeding on the probable cause
Yes, Your Honor.
hearing. So you have Detective Cook, and
Yes.
Detective Cook, I remind you that you were previously sworn in, so you're still under oath.
Yes, ma'am.
All right, and Mr. Linder, take it away.
Yes, Detective Cook. I asked you some questions earlier. You investigated Mr. James for the home invasion with a firearm and robbery firearm that allegedly occurred March 27th of this year in Hollywood.
That is correct.
Okay. And just to supplement your pickup order affidavit, it refers to a neighbor of the victim.
It does.
Okay. And the information he provided about what he witnessed, was that consistent with the victim's version of events?
Yes, so that there were two incidents. There was an initial incident at the victim's house, that the same Honda CRV returned a second time with young black males banging at the front door, and he also saw, as they fled, one of them was in possession of a firearm.
Okay. And you took statements from, one moment, you took statements from some of the co-defendants involved in this case?
4 out of the 5.
All right. And were all the statements given post-Miranda?
Yes.
Okay. And did you receive any information from these statements implicating Mr. James?
Yes.
And could you tell the court what the information you received was?
Yes, I received information implicating Mr. James from several statements. First and foremost was from the victim. The victim's statement stated that all the defendants were known to him. At the time that I first interviewed him, he actually provided me Instagram photos of everyone. In one Instagram photo, Mr. James was actually holding a black handgun in his hand, pointing it at the camera. While the defendant, the victim told me, because he knew these guys and had hung out with them in the past, he had held that gun himself in the past. He knew it held 9 bullets, he knew it was a 9mm, and he knew it was real. When he looked at that gun in the picture, that was the same gun he held that belonged to Mr. James. That was told to me by the victim. The victim also told me that during the initial robbery, when he was seated in the back seat of his car, that Mr. James was seated on his left and defendant Artis Wilson was seated on his right, and that Artis Wilson was in possession of the firearm. However, after he was threatened for the phone and he returned with it, he gave it to James. A short time later, the vehicle returned to the house, and because he thought defendant James was going to try to smooth things over with him, defendant James then knocked on his bedroom window, attempting to lure him to the front door to open the front door of the residence. When he opened up the front door of the residence, he was then confronted by 2 other co-defendants, one of them in possession of the same firearm, and then the home invasion took place.
Now, Detective, the statements and admissions made by Mr. James' co-arrestees,
Yes.
were they factually consistent with the allegations made by the alleged victim?
Yes.
And did you receive any specific information during their statements that corroborated the victim's version of events?
Yes.
Could you please tell the court?
Okay, statements made by the other co-defendants that corroborated. Let's start with Artis Wilson. Artis Wilson stated that there were, once again, 2 robberies, that Rakeem James was seated in the left rear seat of the vehicle. The victim was in the center. He stated he himself was on the right. He stated that Rakeem James brought the weapon to the robbery. He stated, now in his statement, he stated Rakeem James was in possession of the firearm during the first robbery, which is inconsistent with the victim's statement. He then stated that when they went back to the school to pick up the other 2 co-defendants, Rakeem James then gave the firearm to defendant Maurice Jackson, who then went into the home to commit the second robbery. Once again, this story being relayed to me by Artis Wilson is consistent with the victim's story, minus the part where he said that Rakeem James had the firearm instead of himself. However, when defendant Giovanni Spencer, which is Rakeem James's cousin, was taken into custody, Giovanni Spencer, during his statement, admitted that Rakeem James brought the firearm to the robbery and that he handed it to Artis Wilson right before the victim got into the vehicle so Artis could perform the actual threatening with the firearm. This, once again, is consistent with the victim's story that the gun was was in the possession by Artis Wilson. Furthermore, let's see.
Detective, let me interrupt. Did you receive any statement from any of the co-arrestees regarding the purpose of the home invasion?
Yes.
And could you please tell the court the circumstances of that statement, or the details of that statement?
It's going to start with what the victim stated happened. The victim stated that he was originally robbed for a cell phone, and then they came back to his residence, and they stole his Gucci slides. I didn't give any of this information to the defendants when I interviewed them. During Artis Wilson's interview, he stated that they had made contact with defendant Maurice Jackson at the high school first. Maurice had stated that he believed the victim had stolen his cell phone. The other co-defendants, minus Maurice Jackson and Jordan Carter, then went in an attempt to get the phone one way or another. Once they got the phone, they came back, made contact with Jackson and Jordan, who got into the vehicle. They gave him the phone, and he said they went back to the victim's residence to get the cell phone password from the victim. This was all consistent with the victim's statement. So what was your original question you were going on with this?
Did you, were you provided, you mentioned the victim's Gucci slides.
Yes.
Were you given any information regarding those items by any of the co-arrestees?
Yes. While interviewing Artis Wilson about going to and from the victim's residence, he said we had first made contact where we got the phone from the victim, went back and gave the phone to defendant Jackson. Jackson couldn't get into the phone and wanted the password. He said, so we went back to the residence with Giovanni Spencer as a driver to get the password. After they left the residence, he said that Maurice Jackson got upset and said basically, hey, he robbed me. You know, I'm going to show him what it feels like. I want those Gucci slides. Turn around, go back. We're going to go get them. And this was information given to me by Artis Wilson. I had never told Artis Wilson anything about the slides that I knew they had been taken. He gave me that information during his statement. Furthermore, in reference to defendant Rakeem James, he was under, I guess you would call it juvenile probation or monitoring. When Giovanni Spencer was taken into custody, James's monitoring ankle bracelet was in Spencer's backpack. And James had removed it. We were just assuming so when Spencer went to school every day, it would look like James was going to school if you looked at the monitoring bracelet.
All right. I have nothing further, Your Honor.
Okay. Mr. Reese, anything?
I take it I am precluded from cross-examination, Your Honor?
Yes, but if you want to make any arguments or point out
Yes,
any...
as to regard to Mr. James, Your Honor, I think it is still unclear whether Mr. James was ever on the victim's property. Both the relation of the testimony from the detective and the juvenile pickup order referencing Mr. James indicate that the initial robbery took place in the car. Doesn't say that the car ever went onto the property of the victim, but that the victim, I guess, came back outside and gave Mr. James the cell phone through the car window. As in regards to the second robbery, it does not appear that Mr. James ever entered the house or was involved in the home invasion inside the house in any way. It appears that that was the other two individuals who were arrested. Mr. Carter and Mr. Jackson, to be specific.
Your Honor, referring to page 2 of the affidavit, the second paragraph, second sentence, or third sentence, it would appear clear based on the allegations that Mr. James is acting as a principal, luring the victim to the front door so that the other co-arrestees, co-defendants, could commit the home invasion robbery, Your Honor. And I believe.
But he's not charged with being a principal.
Well, Your Honor, as a principal, he's still, even as a principal, he can be charged with the home invasion.
Oh, I see.
There is no principal to home invasion statute, so.
Okay, all right. I find probable cause for both counts. And as I mentioned, I'll let defense counsel prepare their case to go before the division judge to address the bond and pretrial and release conditions.
And Your Honor, can I just very briefly, in case writ's filed, Your Honor, the state would just argue, if the court had chosen to make a determination today, the state believes the evidence provided would satisfy a finding of proof evident or
I'm
presumption
sure you
grade.
do, and I'm sure that they don't.
I know, I'm just making.
Just the hunch.
I understand, Your Honor, just need to put it on the record, that's all.
All right, very good. Thank you very much, Mom, for being here.
Judge,
Mr.
are you
James,
holding
you're very
this-
fortunate to have your mom here, you know that.
I don't know.
All right, you should thank your mom for being here because I don't see many moms in the audience, and you're very lucky to have your mom here because God bless her. And yes, Mr. Reedy.
Are you holding Mr. James no bond, Judge?
Yes, during the pendency of the
And the rationale for that is what? What's the legal basis for that?
Arthur hearing, the need for an Arthur hearing to allow defense counsel and state to prepare for the Arthur hearing absent a pretrial detention motion by the state. I'm not conducting an Arthur hearing or a pretrial detention hearing at magistrate, and I'm not making a finding of proof evident presumption grade. And for the reasons that I stated previously, which were I'm sure were a lot more eloquent than I'm stating now, because I was in the.
And, Your Honor, I apologize, I would also just, in an abundance of caution, ask for an order of no victim contact.
Okay, yes, and no victim contact with
Is
Mr.
Mr. Washington in the courtroom?
So,
Detective Cook, what's the victim's name?
hold on.
I'm sorry?
The victim's name?
Joel Oliva.
And no
Y-O-E-L, Oliva.
Okay, and no contact with the victim, Joel Oliva. Okay, all right, thank you.
Yes, ma'am.
Are you gonna hire your own or do you wanna pay?
Your Honor,
Yes,
I know there's two other co-defendants. Might stick around for this.
If we could, Your Honor, if we could just bring, once they move him
can we,
back, if we
yeah,
could bring the
Mr.
next one
Upsall,
down.
can we
and
get Mr.
Either,
Artis, or Mr. Wilson next, please?
I'll let the deputies know, Judge.
Thank you.
They're bringing him.
I have, only because I have a detective here that's waiting to testify on all
no,
three co-defendants. I do appreciate that, jail personnel. So yes, Detective Cook, if you could just have a seat, hang out, I'm sorry. All right, Jonathan Poe. Jonathan Poe, Mr. Poe, you're charged with a violation of probation in a felony case. I find probable cause for that VOP and you're being held no bond. I cannot and will not disturb that no bond because I cannot. The good thing is that you're going to go see the division judge on April 18, 2017. Good luck to you, sir. Thank you. Johnson Edmund. Mr. Edmund, good morning, sir. You're charged with a violation of probation in a felony case. I find probable cause for that VOP and you're being held no bond in that case. I cannot disturb that no bond. The good news, sir, is that you're going to go see your division judge on April 18, 2017. Good luck to you, sir. Charles Smith.
That's no problem, Your Honor.
All right, thank you. Mr. Smith, good morning. How are you?
All right, man.
Mr. Smith, you're being charged with a violation of probation in a felony case. I find probable cause for that VOP, and you're being held no bond on that VOP. I cannot disturb that no bond status. But the good news is that you're going to go see your division judge on April 18, 2017. Good luck to you, sir.
All right, thank you.
You're welcome. Andre Brown, back to main jail. All right, Mr. Brown, welcome, sir. You're being held on 3 capiases. Count 1 is a capias for a misdemeanor case. I find probable cause for that capias, seeing as that it was signed by that division judge, and you're being held no bond on that one. I cannot disturb that. Count 2 is a capias on a felony case that was signed by that division judge, and you're being held for no bond on that one as well. And count 3 is a capias for the same felony case, and you're being held no bond on that. Sir, you're going to go see the misdemeanor judge on April 24, 2017. Good luck to you, Mr. Brown. Willie Neely?
You got court.
Come back to North Broward, Your Honor.
All right, Mr. Neely, how are you, sir?
How you doing today?
I'm doing very well, thank you for asking. Mr. Neely, you're charged with, you're being held on a violation of probation on a felony case. I find probable cause for that VOP, and you're being held no bond on that VOP by that division judge, so I cannot disturb that. The good news is that you're gonna go see the division judge on April 24, 2017. Thank you, sir, good luck to you.
All right.
James Fonseca. Broward. All right, Mr. Fonseca. Sir, you're being held on 2 counts of violation of probation on 2 separate felonies. Count 1, I find a probable cause on that VOP signed by that division judge, and you're being held no bond on that. Count 2 is a violation of probation. I find probable cause for that, and you're being held no bond on that as well by that division judge. I cannot disturb it. The good news is that you're going to go see your division judge on April 18, 2017. Good luck to you, sir. Kamar Campbell, back to me.
Judge, Mr. Lender is going to give me a copy of that probable cause affidavit momentarily.
For Mr. Campbell?
I've been advised to decline the public defender's
Oh,
office.
okay, never mind then.
All right, Mr. Campbell, you've declined the assistance of the public defender's office, so you're going to proceed on your own. But I'm going to advise you, sir, you cannot talk to me about the facts of the case. Mr. Campbell, you're charged with aggravated stalking as a domestic violence, and count 2 is intimidation, writing, sending, threatening to kill or injure. I find probable cause as to both counts. Judge Ross, Stacy Ross signed that warrant for those, so I do find probable cause as to the bond amount. State?
Your Honor, you have the affidavit, correct?
Yeah.
Okay. Your Honor, and I'm not going to go into any details, I am very concerned for the victims, based on these allegations, the victim's well-being. I'm concerned for her life, actually. Your Honor, I'm going to be requesting bonds in the amount of, Kiefer, please, $150,000 on 1, $100,000 on 2, no victim contact, pretrial release with a GPS monitor level 1.
All right, Mr. Campbell. The state is requesting $150,000 on count 1 and $100,000 on count 2. Do you have $250,000? Mr. Afzal, can you turn the microphone on for Mr. Campbell? Oh, it is? Okay.
Yes,
You have it? Okay.
I would say.
All right, so we'll set the bond at $150,000 for count 1, $100,000 for count 2.
And Your Honor, I apologize. The only other thing, and I
You know how much that is?
forgot to mention this. Based on one of the statements he made about his intentions to return to Jamaica, I would ask for a passport surrender.
Okay. Mr. Campbell, I'm going to also order that you have no contact with the victim, Miss Julianne Campbell, I believe. Is that right? Am I right?
Yes, you are, Judge.
Can you reduce the bond?
No. Do not. This is what happens. You do not get to interrupt me, Mr. Campbell. You are that ship has sailed. We already discussed that part. We're going on to additional pretrial release conditions, which include no contact with Julianne Campbell, not directly, not indirectly, not through pigeon mail, not through text messages, nothing. Understood? Mr. Campbell, do you understand those instructions?
Pardon me?
Do you understand those instructions that you are to have absolutely no contact with Miss Julianne Campbell?
Yes.
Okay, I'm going to order you, sir, also, if you do have a passport, to surrender your passport. A passport surrender. I'm going to also advise you, Mr. Campbell, you understand that if you do have any contact with Miss Julianne Campbell, you're exposing yourself to additional criminal charges. You understand that?
Yes.
And,
all right.
Your Honor, what we would ask is, well, you know what, because I don't want to trip him up. I don't know if the court wants to inquire under oath if he is in possession of a passport. If he's under oath saying he doesn't, then that I would be satisfied with that.
Do you have a passport, Mr. Campbell?
Yes.
Okay, then you need to surrender that passport.
And Your Honor, I would just ask that it be within 24 hours of his release.
Okay, within 24 hours of your release, you need to surrender that passport.
To
Otherwise, you may be violating the terms of your release. I'm going to also order you, Mr. Campbell, to be put on pretrial release with level 1 electronic monitoring. And they'll, I'm sure, will give you further instructions as to the surrender of that passport as well.
Yeah, and Your Honor, just so and he knows, I'm going to be asking that it be surrendered to the clerk of the court.
Right, to the clerk of the court, but I'm sure pretrial release will
Yeah,
go ahead and tell him.
they
what the
will.
clerk of the
Thank
court
you,
is.
Judge.
You're very welcome. All right, thank you very much, Mr. Campbell. Good luck to you, sir.
Thank you.
150.
Christopher Spivey. All right, Mr.
Yes,
Spivey, how are you, sir?
Good, how are you?
I'm doing very well, thank you for asking. Mr. Spivey, you're charged with a violation of community control in a felony case. I find probable cause for that community control since it was a violation of community control since it was signed by that division judge. And I cannot disturb the no bond that was set by the division judge. The good news, however, is that you're going to go see the division judge on April 18, 2017. Good luck to you, sir.
And Your Honor, I see a little bit peeking out. I think we might have one of the other juveniles.
Oh, do we have either Mr. Wilson or Jackson here?
Yes.
Very good.
Did they bring Jackson or they?
Is it Wilson?
Yes, ma'am.
All right, Mr. Artis Wilson. Sir, you're here for your magistrate.
Do you?
I believe.
I'm going to adopt the same exact arguments that we adopted in the previous one, just to not reiterate, and the same exact reasoning as to why we're not going to have the Arthur hearing and we're not going to discuss bond on Mr. Wilson as well. As
And
far
for
as,
the record, I would incorporate my arguments with regard to Rakeem James as to Mr. Wilson's case as well.
as far as probable cause is concerned as well, and as far as the,
As far as the court's legal standing is not addressing the issue of proof, evident, presumption, great, and holding Mr. James no bond pending an Arthur hearing in front of whatever division judge is assigned to the case, which I believe was the court's reasoning in Mr. James' case.
yes,
And I expect it to be the same in Mr. Wilson's case.
yes,
And the state.
And my
obviously
argument's the same.
And the state obviously just adopts its same argument. Your Honor.
okay. All right, so as far as probable cause is concerned, Mr. Wilson, do we need to hear from Detective Cook again?
Detective, if you could briefly, if you just have any additional information you could provide to the court, briefly, please.
The only additional information in reference to this case I'd like to provide to the court that I haven't discussed already is that after the first initial robbery, which was established by Giovanni Spencer and the victim, in which Artis Wilson was the one in possession of the firearm conducting the threat for the phone, during the home invasion robbery, at the conclusion of the robbery, as suspects Maurice Jackson and Jordan Carter fled the residence with the victim's property, Artis Wilson, through the observation of the victim and through his own statement to myself, then took position into the driver's seat of the getaway vehicle and fled the scene as the driver of the vehicle to facilitate getting away from the robbery. I gave this information to the Miramar Police Department, and they actually recovered the stolen vehicle in front of Artis Wilson's residence that night.
Okay, Mr. Reedy?
I would make a similar argument to the one I made on behalf of Mr. James. It does not appear as though Mr. Wilson went to the residence during the commission of the home invasion, the actual home invasion robbery itself. I do see where the court could possibly find probable cause as to the robbery of the phone that took place in the car. But again, as I argued previously, there's no indication here or from the testimony of the detective as to whether that car ever entered onto the property of the victim in the case. And it does not appear as though Mr. Wilson himself ever went inside the residence or was seen outside the residence by the victim. I think when he says, if according to the report, he saw Mr. James standing outside with Mr. Jackson.
And Your Honor, I would just argue again, to be a principal, he doesn't have to be an active participant in the actual home invasion. The court is aware, obviously, the law, principal theory. He just has to provide assistance. It would appear, based on, Your Honor, the facts surrounding the circumstances, it would appear, based on testimony, he was aware of the robbery that was to take place and provided support as a getaway driver.
Okay, all right, I do find probable cause for both counts, count 1 and count 2, and as I mentioned, the defense and state will be given an opportunity to address the bond at a later.
Judge, will the court provisionally appoint us? I know they're, in order for us to make a withdraw in the case for conflict counsel to be appointed, we have to be appointed and submit a motion to withdraw.
Yes.
on one of the co-defendants. So I'd ask the court to provisionally appoint us to represent them.
Yes, I'll provisionally appoint the Public Defender's Office on Mr. Artis Wilson's case.
So the record's clear, I've been in touch with our office on all three defendants, and as I understand, what our intention to proceed is to be provisionally appointed on all three this morning, and then we'll sort out where we go from there.
And
Thank you, Mr. Reed.
And I can't remember if you did already, we just asked for no contact also.
Oh, and no contact with the victim.
Mr. Yoel.
Joel Oliveira?
Joel.
Oliva. Joel Oliva. Okay. Very good. Thank you very much, Mr. Wilson. Hopefully we can get Mr. Maurice Jackson here as soon as possible. Deputy, Mr. Upsall?
Yep, we're working on getting him now.
Perfect. Ariel Rodriguez.
Kifa, I need you to...
Ariel Rodriguez, he's at the main jail. Sleeping. Ariel.
I need you to mark these out, please.
He's on page 16 on the bottom. Ariel Rodriguez. Oh, he was released. Never mind. Okay. Oh, yeah, that's right. All right, well, I find probable cause for the violation of probation that was signed by the division judge. Emery Jones. All right, Mr. Jones, welcome, sir. You're being charged. You have 3 counts of violation of community control and a felony count. I find probable cause for count 1. That violation of community control was signed by the division judge, and you're being held no bond on that. I can't disturb that. Count 2 is a violation of community control as to another felony. I find probable cause for that violation of community control, and you're being held no bond on that by that division judge. I cannot disturb that. And count 3, you're being held on a violation of community control on another felony, and you're being held no bond on that. I cannot disturb that. Thanks. The good news is, sir, that you're going to go see your division judge on April 18, 2017. Good luck to you, sir.
Court date May 5th.
May 18th.
Oh,
I mean,
on
tomorrow.
the 18th.
April 18th.
Yeah.
Christian Adams. Christian Adams is coming up. All right, Mr. Adams, there he is. You're charged with count 1 is burglary, unoccupied dwelling, unarmed. Count 2 is grand theft. And count 3 is trespass of a property, not a structure or conveyance. Any probable cause argument, Mr. Reedy?
I thought the identification here was very weak, Judge. It says he's observed by the witness. It doesn't say who the witness is. And there's nothing later on following up, whether there was a photo lineup, a show up, anything along those lines to indicate that Mr. Adams was the one who was seen at the house removing the generator. And it doesn't appear as though he is in possession of any of the stolen property as well. So I don't think that there's probable cause for the court to make a determination that Mr. Adams is the one who was seen removing the generator.
State?
Well, Your Honor, for PC, I don't think they need to have the name of the witness.
No, but you need to have ID. That's for sure. That's one of the elements. In everything, I think.
One moment, Your Honor.
You want 24 hours?
That's fine, Judge.
All right. In the meantime, 24 hours to perfect as to probable cause. I'm not finding probable cause on any of the... in the meantime, count 1. I need to give him a bond, right?
Well, no, Your Honor, you can be held till tomorrow.
Mm-hmm. Okay. All right, 24 hours, Mr. Adams. Thank you, Mr. Abzal. Luis Lopez in North Broward.
North Broward.
All right. Mr. Lopez, how are you, sir?
Good, man. How about you?
I'm doing well, sir. Mr. Lopez, you're being held on a capias that was signed by Judge Yuson for the charge of failing to redeliver a hired leased property of $300 or more. I find probable cause for that capias that Judge Yuson signed for you originally. And the bond that was set by Judge Yuson is $1,000, so I am not going to disturb that bond, Mr. Lopez. Good luck to you, sir.
Louis, you're going to have to go in front of Judge Usan, okay?
Okay.
All right, we'll try and get you there as soon as we can.
What? Thank
Hi,
you.
sir. James Mulkey. Mr. Mulkey, welcome, sir. You're charged with a violation of probation in a felony case, and you're being held no bond. I find probable cause for that, and I cannot disturb the no bond. Good news is that you're going to go see your division judge on April 18th, 2017. Good luck to you, sir.
Thank you.
You're welcome. Dondre Collins.
In my home.
All right, Mr. Collins, welcome, sir. And just as a side note, do we have Mr. Jackson there, Mr. Afzal? Is Maurice Jackson already there?
Maurice Jackson? Is he here? Yes, Judge.
Okay, well, let's do Mr. Collins. Let's get Mr. Collins out of the way since he's already standing there. Mr. Collins, sir, you're charged with 8 counts. Count 1. Hold on a second. All right, count 1 is a violation of probation and the felony case. I find probable cause for that VOP. And you're being held no bond on that. Count 2 is burglary unoccupied of a dwelling unarmed. That's pursuant to a warrant that was signed by Judge Siegel. I find probable cause for that warrant, and the bond that Judge Siegel set on that was $15,000. I am not disturbing that. Count 3 is grand theft. It's a first degree. Pursuant to a warrant that was signed by Judge Siegel, I find probable cause for that warrant that was signed by Judge Siegel. The bond that Judge Siegel set on that was $7,500. I'm not disturbing that. Count 4 is burglary, occupied, dwelling, unarmed, pursuant to a warrant that was signed by Judge Siegel, I believe, as well. I find probable cause for that warrant, and that bond that he set was $7,500 on that. I'm not disturbing that. Count 5 is a violation of probation. Find probable cause for that, and you're being held no bond. Count 6 is a violation of probation or community control. Find probable cause for that, and you're being held no bond. Count 7 is a violation of probation or community control. Find probable cause for that, and you're being held no bond on that. And count 8 is a violation of community control, and find probable cause for that, and you're being held no bond on that. So you're going to go see your division judge on April 18, 2017. Good luck to you, sir. Thank you. All right, let me get Mr. Jackson, Maurice Jackson, the last of the... All right, Mr. Jackson. Sir, this is a non-adversarial. I provisionally appoint the Public Defender's Office to Mr. Jackson's case as well. Sir, this is a non-adversarial hearing. We're going to go ahead and hear regarding probable cause from Detective Cook. I adopt the same arguments that I adopted previously as to the Harther hearing. I'm sure the Public Defender's Office adopts the same arguments that they did, and the State Attorney as well.
We would incorporate those arguments, Judge.
Okay.
State as well.
All right, very good. Mr. Linder, take it away. Detective Cook is present. I remind you, Detective Cook, that you've been previously sworn in and you're still under oath.
Yes, sir. And Detective Cook, in addition to the testimony you provided with regard to the Mr. Jackson's 200 co-arrestees, do you have any additional information you can provide to the court regarding Maurice Jackson?
Yes.
Please, if you could.
Additional information regarding Maurice Jackson is, upon taking his statement, he originally told me that though he did know the victim, he's never been inside the victim's residence. However, our latent examiner did obtain a thumbprint of Mr. Jackson's, his thumbprint from the victim's bedroom door, which the victim had barricaded himself inside the bedroom before the door was barricaded. Upon confronting him with this evidence showing he had been inside the residence, he then finally admitted that yes, there was a robbery, but that things had gotten out of hand. He also corroborated that he was in the residence with defendant Jordan Carter, and that Jordan Carter forced the victim's bedroom door open with a knife and put it in the sink. We did find that knife in the sink. He then stated he never had a firearm, though the victim's statement was that Maurice had the firearm. I then confronted Maurice with the information that he was seen with a firearm by the next door neighbor leaving the residence, which he then stated that Rakeem James had also entered the residence. If this is true, that would just simply mean that he did not enter the victim's bedroom. The victim did not see Rakeem James in the bedroom, that he was just inside the front door. But according to Maurice Jackson's statement, that Rakeem James had dropped the firearm as they were before they left the residence in the living room, and that he picked up the firearm and ran out of the house carrying, and that's the only reason he was seen with the firearm by the neighbor. However, Maurice Jackson did confirm with me the same motive for the robbery that all the other co-defendants interviewed separately had told me, was that it had started over a cell phone he believed was taken by the victim that belonged to him. And then after his co-defendants had retrieved the cell phone for him, it didn't work because he did not have a password, at which time he wanted to go back to get the password, which is once again consistent with everyone else's statements on the coming and going and the reasons why they came and went. And like I said, he did admit that they went and took the victim's property once they were inside the residence, including the Gucci slides.
Nothing further, Your Honor.
Okay, Mr. Reedy, response?
I'd incorporate my previous arguments reference to Mr. Jackson, Judge.
Okay, very good. I will find probable cause for the charge of home invasion with a firearm or other deadly weapon. And thank you, Detective Cook, for being here. I believe that you are free to go if you like.
Thank you.
You're very welcome, and I'll allow counsel an opportunity to prepare for that bond hearing. Thank you, gentlemen.
Thank you, Your Honor.
Lázaro Blasco. Main jail. Mr. Blasco, welcome, sir. You're charged with a violation of probation warrant that was signed by a judge. I find probable cause for that, and you're being held no bond on that warrant. I can't disturb that, but the good news is that you're going to go see your division judge on April 24, 2017. All right, sir? Thank you. Shannon Cham, North Broward. All right, Ms. Cham is...
Right here.
Their Cham is present. Mr. Cham, you're charged with driving while license suspended, revoked as a habitual traffic offender, and you have count 2, driving while license suspended as a habitual traffic offender. Okay, so I'm only setting a bond on count 2, right?
Yes,
Yes,
ma'am.
Your Honor.
Okay. So any probable cause arguments?
No, Your Honor.
All right, I find probable cause for count 2, driving while license suspended as a habitual traffic offender. As to the bond, Mr. Reedy?
Judge, Mr. Cham indicates that he can probably make a $750 bond. I don't know what his prior record is, but I'd be asking the court to maybe reduce it to $500.
He's got to at least have 3.
I'm sorry?
He's got to at least have 3 of these.
Yes.
So I can state, Mr.
I know, I
Linders?
understand.
No, that's, I mean, I'm not asking for any kind of bond increase. I'm just asking that the convenience bond be kept in place.
Well, he certainly cooperated, Judge. He said to the police officer, my license is suspended, and handed him the Florida ID card. So, I mean, he's cooperated.
Pretty sure he was going to figure that out when he pulled his record.
Appreciated that you put that address under the fraudulent category.
All right, I'm going to reduce the bond to $500. Good luck to you, Mr. Cham.
Thank you, Judge. Have a good day.
You too, sir. Walter Simmons. Main jail.
Main jail.
All right, Mr. Simmons, you were charged, sir. Count 1 is dealing in stolen property, and count 2 is false ownership, owner information, pawned items. Any probable cause argument?
No, Your Honor.
All right, I find probable cause for counts 1 and 2. As far as the bond amount is concerned, Mr. Afzal?
Judge, just in speaking with him, he's a resident of Fort Lauderdale for 36 years. He currently lives in the house. He has a roommate. Grew up down here, went to high school here. He's gainfully employed working at a Publix warehouse. Yeah, he's just lost his job. He was employed there for a month. He has no money in the bank, no property. He has no ability to post bond.
Mr. Linder?
I don't know that he's been a resident the past 10 years. 06, robbery, firearm, deadly weapon, sentenced to 10-year state prison. He got out February 27th of last year.
So I guess technically he has been a resident for 10 years since he was...
Not down here. I don't know. His prison...
36 years, Judge. He grew up here.
He said resident down here.
He is
Prison
36 years
was
old.
he,
37.
I don't think he was in prison down here.
When he got out of prison, he came down to Fort Lauderdale. That's where he's from.
So what are you asking for, Mr. Afzal?
Judge, I asked him if he can afford a $7,000 bond. He can't. I mean,
So what do you
He
want?
can't afford any bond. I would ask for pretrial release.
Oh, there's no way he's going to be our. There's
Well,
just.
if-
I mean,
if
let's
he-
be realistic.
You asked me how much he can afford in bond. He can't afford any monetary bond.
He's had failures to appear. If he can't afford, then, Your Honor, if he can't afford any monetary bond, then I would just ask that the convenience bonds be left in place, considering he's out of prison within the past year on a violent felony.
Yeah, I can't. I mean, I'll just leave the bonds the way that they are, $3,500 for each bond. I can't ROR Mr. Simmons. I'm sorry. I'll allow you if you get. I'll allow you to I will allow the division judge to modify that bond upon you guys filing a motion if you like. Thank you. Alexander Pierre.
Sick and tired of talking to you. You have a good day.
All right, Mr. Pierre, you're being held on a violation of community control in a felony case, and you're being held no bond on that by the division judge. I find probable cause, and I cannot disturb the no bond. You're also being held on a violation of probation on the same felony case, and you're being held no bond on that. I cannot disturb that. You are going to go see your division judge on 4/18/2017. Good luck to you, sir. Thank you. Curtis Grant, North Broward. How are you, Mr. Grant?
How you doing, Judge?
I'm doing well, thank you for asking. Mr. Grant, you're being held on 3 counts. Count 1 is possession of cannabis 20 grams or less. Count 2 is a violation of probation or community control. I find probable cause for that warrant, and that is being held no bond. I can't touch that. And count 3 is an out-of-county hold, where you're being held no bond as well. I can't touch that either. As to the possession of cannabis charge, any probable cause argument?
No, Your Honor. It appears it was in his pants pocket and field tested positive, and he admitted that he had it. It's unfortunate he's got the probation violation. I'd ask you to resolve the cannabis charge, but that really won't do him any good because he won't be able to respond to the out-of-county hold until he takes care of the probation violation.
Right. So I'm going to, I'm not inclined to disturb the bond since he's going to be in custody. Mr. Grant, you got to take care of that violation of community control bond. Then you'll be able to take care of the possession of cannabis. But then I don't know if you really want to take care of the possession of cannabis. You'll be able to post the $100 bond so that you can go to Palm Beach on that out-of-county hold so that you can take care of that. Because if you take care of the possession of cannabis charge, you may be violating that probation or parole. Community control, sorry. All right?
Good advice, Judge.
I have a question.
Yes.
So what you're saying is I have to go to Palm Beach first?
No, you're going to have to stay here, resolve that community control case. Then, because you have a VOP. Oh, it is?
My VOP is in Palm Beach, Your Honor.
Okay, gotcha. All right, so you need to, yes, but you need to post the $100 bond on the cannabis charge?
Consider RORing him,
yeah,
Judge, so we
can
can
I
get out of
stay-
Broward and get going, because...
What's the new offense?
Possession of cannabis, 20 grams or less.
That's fine.
Okay, so I'm going to ROR you on the possession of cannabis charge so that you can get transported over to Palm Beach, okay?
This guy.
Yes, ma'am.
All right, take care, sir. Good luck to you. Veron Andrew? Oh, sorry. All right, Mr. Andrew, you're charged with possession of cocaine, and I have an issue with no field test positive.
I agree,
Am the only
Judge.
one? Oh, I
Yes.
just saw the FTP in parentheses. Never mind. Any probable cause? Yeah, it's just in the middle there.
Oh, okay.
Now I see it, okay.
I didn't see it either. I guess I. All right. Any other? I find probable cause for the possession of cocaine charge and anything on bond.
Well, pretrial standing up on the last sentence.
It's currently on pretrial for case number 160036.
I know the case. Gonna revoke your bond.
And just noting, apparently he was on a GPS monitor. Says he was wearing an ankle monitor. So and that wasn't apparently enough to deter this.
Is it filed? Is the
Yes.
case filed?
Yes.
That other case, that other felony case, which is 160033623,
Is filed.
is filed.
Yes.
Does he have any crimes of violence in his past? Maybe the court can take other restrictions. They can place him on level 1 house arrest. They can have him go to a drug program, have him go to a Barkerville.
Well,
He was on level 1. He was on electronic monitoring
it
already.
might not have been level 1, but still,
Right, but
I
he
mean,
was already on electronic
yeah,
monitoring.
yeah. And also, it looks like he picked since this incident. He picked up I don't think he was being supervised on it, but he picked up a resisting without violence that appears to be open also.
You know what? Let's reset Mr. Andrew for this afternoon, and I need the probable cause affidavit on that 1600362 CF10A, please.
If you want to put on a brief recall, I can get it for you right now.
Or
It's
we
up to
could
you.
just reset him to this
No,
afternoon.
I'm just giving you the option, whatever you want to do.
Yeah, we could just we'll reset him for this afternoon.
Okay.
Reset to 1:30. Do we know what our 1:30 looks like?
No, not yet.
I do appreciate your belief in my fast reading.
Just want to give you the option, that's all.
Alvin Johnson. Alvin Johnson, very good. Mr. Johnson, you're there. Sir, you're charged with count 1. Good morning. Sir, you're charged with count 1 is possession of a weapon or ammunition by a convicted felon. Count 2 is possession of cannabis over 20 grams, and count 3 is possession of cocaine. Any probable cause argument, Mr. Reedy?
I think these next two cases at least are all the same arrest location, the next 3 cases on the docket. I wasn't sure exactly where I guess in rereading it now, it looks like the ammunition was found allegedly on the side of the bed in a backpack, or storage bin in the closet, and some on the, okay, no, I don't have a probable cause argument at this time, Judge, on that.
All right, FM probable cause for all 3 counts. As far as the bond is concerned, count 1. Mr. Afzal, briefly?
Yes, Judge, I can tell you he's been a resident of Pompano Beach all his life. I'll be respectfully asking for a $1,000 bond. He currently lives in the house. He splits, rent is about $800 a month. He splits rent. I would ask for a med screen. He's currently receives disability, $700 a month. He has about $300 saved up towards, which he said he could use towards a bond.
Okay. Mr. Linder?
Yes, Your Honor. Out of Port Orange, 2013, paraphernalia. One moment, Judge. Then you go back to, Your Honor, 1993 Bat Leo, he went to prison. 93 Bat Leo, he went to prison. I don't have a problem with 1,000 on count 1, 3,000 total bond.
All right, so what are you asking for, Mr.?
I was asking for a total bond of $3,000 or $2,500.
All right.
He has about that much saved up if he were to put the 10% down.
All right, I'll do count 1 will be $1,000, count 2 will be $1,000, and count 3 will be $1,000. Thank you.
Thank you.
You're welcome. Melvin Mitchell?
Present at the main.
Yep.
Good morning, Judge Robertson.
Good morning, Mr. Mitchell. How are you? I like your energy. All right, Mr. Mitchell, you're charged with count 1 as possession of a weapon or ammunition by a convicted felon, and count 2 is possession with intent to sell, manufacture, or deliver cannabis. Any probable cause argument?
No, Your Honor.
All right, if I have probable cause for both counts. And as far as the bond on count 1, I'm inclined to do the same that I did for the previous individual.
That's between you and the bondsman.
Your Honor, the only... He has a more recent history, delivery of marijuana and cocaine, 2012. Also, he had a violation of pretrial release conditions from 2010, concerned about following court orders. I was going to be asking for $2,500 on 1 also. One moment.
Mr. Absal?
Judge, I can tell you that he's grew up here. He currently resides in a house where he rents a room in Pompano Beach. He pays rent $125 a week. He just recently graduated from cosmetology school. He's gainfully employed at Checkers, where he's been working for 2.5 months. He does have family here. He has a sister that's a drill sergeant in the Army. He can afford about $200 towards bond. Things are a little tight right now, paying rent. I would ask court to set bond at $1,000, count one.
Mr. Mitchell, what cosmetology school did you go to?
I went to American Institute. I just graduated March 31st.
Oh, wow. Well, congrats. How long was that program that you did?
It was 12 months.
Who paid for that?
I have financial aid.
Your Honor, additionally, based on the allegations, it appears there might be supplemental income coming in.
All right, I'll set the bond on count 1 at $1,500, and count 2 will be, I'll leave it $1,000.
So it's 2,500.
Thank you. Bernard Grant.
He bonded.
Oh, very good. So I give it to you, just straight up? All right. Stanley Messidor.
Present at the main.
Mr. Messidor, you're charged with count 1 is grand theft of a firearm. Count 2 is possession of cannabis 20 grams or less. Count 3 is possession with intent to sell or manufacture or deliver cannabis. Count 4 is possession of drug paraphernalia. Count 5 is a capus on a misdemeanor case where you're being held. Is it no bond or $500 bond?
500.
Okay. I'm not going to disturb that, and I find probable cause for that capias. Count 6 is a capias on the same misdemeanor case that was signed by the judge. I find probable cause for that, and I'm not disturbing the $500 bond. As to counts 1 through 4, any probable cause argument?
No, Your Honor.
All right. I find probable cause as to all 4 counts. And as to the bond, Mr.
Judge, I would just ask, would the court consider either ROR in counts 2 and 4? I could tell, if you want me to tell you about his ties, he does have 2 jobs. He works at the Amazon warehouse, and he also works at Walmart.
Your Honor, I think the convenience bonds are reasonable considering he's out on an offense that he didn't show up to court on. According to this, he's driving a 2013 Mercedes.
Is that your Mercedes, Mr. Messidor?
Excuse me?
Is that your Mercedes that you're driving?
Yes, ma'am.
You own it?
It's like actually rented. It's like a rental.
So then, from where?
From a person that a person.
Can I just talk to him briefly? Briefly about that.
You know what? I'm not going to disturb the bonds. I'm going to leave them at the convenience bonds. Count 1 is going to be $1,000. Count 2 it will be $100. Count 3 will be $1,000, and count 4 will be $100. Seems like he may be able to afford it based on the vehicle he's driving. Thank you. Marcus Beecham, main jail. All right, Mr. Beecham. I need Mr. Beecham. Come on up. Mr. Beecham, you're charged with count 1 is neglect of a child with great bodily harm, and count 2 is selling cocaine. Any probable cause argument as to the charges?
I don't see a neglect of a child.
Yeah, I don't see the kids either.
One moment, Judge.
I mean, they say kids, but they don't say the ages. They don't say any. So I.
Or where they even are.
Well, they're in the car or something. Yeah, I don't. Yeah, I don't know.
I mean, Your Honor, well, wait, it does. It says on the second to last page, it has his date of birth.
Jamarcus Beecham?
Yeah. And, Your Honor, I would ask that the name be redacted.
Yeah, he was inside the vehicle sitting in the middle seat during the hand-to-hand narcotic transaction between Doherty and Beecham.
And, Your Honor, I would just ask for the court to order if anyone makes a public records request for the transcript that the juvenile's name be redacted.
Okay, yes, that is granted.
I must have a different probable cause affidavit. I don't have anything about Mr. Beecham being inside the vehicle.
The second to last page, do you have that one? Mr. Reedy, look at this.
No, I definitely do not have what you have.
All right, here. Madam Pretrial Release, could you please be so kind? Thank you.
Just one moment.
Sure, take your time.
Totally different probable cause affidavit.
right, just as a side note, Jerome Parkinson, I'm seeing that it was reset.
Yes.
Oh, sorry, it was reset from another. Okay, never mind. I misunderstood.
Has been reset. I can say something, Chief.
Thank you, Judge. I've had a chance to read that probable cause affidavit, which again is very different than the one I have. I don't know if there's neglecting child with great bodily harm here. I think it might be probable cause for a lesser of child neglect.
The great bodily harm does
Yeah, no,
require that there be some,
It should
is
be.
that one of the elements on that one?
It should be child neglect without great bodily harm.
Without, right? Okay,
Yes.
so I'll find probable cause for the lesser. Can I do that?
Yes, you can.
I do not find probable cause for neglect with great bodily harm.
Your Honor, all you have to do is you can find PC and just write under it child like without great bodily harm, or without great bodily harm.
250150, please. Step 4.
Okay, and I find probable cause for the selling cocaine charge. As far as the bond is concerned, on count 1, the neglect.
Judge,
Yes, Mr. Upsall?
Judge, I can tell you that he's a resident of Broward County all his life. I can tell you that he does work odd jobs. I can tell you he does landscaping. He does some demolition work. He was on his way to work. The co-defendant in the case owed him some money. Now, I understand the court has already found probable cause, but that was money owed, not a hand-to-hand transaction for drugs. That's something that I can raise later on when we're working on its defenses, but I thought the court should at least hear that.
Okay.
I can tell you that he lives at his mother's place in Hollandale. He does landscaping. He does about 10, 11 years he's been in that business. He's been relying on it. He has all his family down here. We're relying on his brother to bond him out. The most he can afford is a maximum $200.
Mr. Linder?
One, just briefly, there's some other allegations in here that would seem to indicate this is more than just someone paying Mr. Beecham back some money. Your Honor, according to Florida Department of Law Enforcement, he is classified as a career offender. His record includes 2001 resisting with violence, possession of cocaine, tampering evidence. He was sentenced to 5 years in a day state prison as a habitual offender. Delivery of cocaine out of Near Park and possession of cocaine in 99. 28-month state prison as a habitual offender. Possession of cocaine 99, same sentence. Possession of cocaine 97. 95, same offense, 15 months. Delivery of cocaine 94, 22 months. Delivery of cocaine 93, a year. Possession of cocaine 93, a year. Just multiple other possession and or delivery of cocaine priors. Your Honor, based on these allegations and the fact that there was an 8-year-old present in the vehicle, I'm going to be asking for a $5,000 bond on one for a total bond of $7,500.
Judge, as to count 1, the $5,000 bond is the bond he can't afford. I could, just based on I don't believe the child was harmed. There were no firearms used during the transaction. I would ask the court to take that into consideration in setting bond.
Also, taking into consideration how much cash was allegedly on Mr. Beecham's person when he was arrested.
All right, I'm going to set the count 1 at $5,000 and count 2 I will leave at $2,500. Thank you, gentlemen. Actually, sorry. Count, take that back. Mr. Beecham, come on back. Count 1, which is now neglect of a child without bodily harm. I'll set at $2,500. For a total of $5,000 between count 1 and count 2. Thank you. All right, Mr. Kevin Doherty. I'm having a hard time with Mr. Doherty's PC. Mr. Doherty, you're charged with count 1 is selling cocaine. Count 2 is possession of cocaine. Count 3 is selling cocaine in a separate incident. Am I right?
Yeah, there's one. Yes, Your Honor.
And actually, one incident was with Mr. Beecham.
Yes.
And okay, so this is what was confusing me a little bit. And then count 4 is a capias. I find probable cause for that capias in a misdemeanor case, which is a misdemeanor ordinance, and that bond is $100. All right, let's do any probable cause argument as to the.
Well, as to the one transaction, I don't know. It seems almost more like purchasing cocaine than selling cocaine.
No, he handed him.
Oh, I see, okay.
Yeah,
Driver
Doherty handed him-
Doherty a small palmable object. That sounds like the blackmail driver handed something, which we don't know what it is, to Mr. Doherty.
And then Doherty then responded directly back to the detective Flores' undercover vehicle and handed him 2 small rocks of crack cocaine.
Okay.
And then, but this is what makes it weird, because then he's charged with possession of cocaine, and then apparently when he gets arrested, or something to that effect in this 3rd paragraph, Doherty dropped 2 pieces of crack cocaine to the floor from his left hand.
Wouldn't that be the same cocaine then?
I don't think so, because I think the other one he had just given to Detective Flores.
Okay.
That's
All
what
right.
got me
It
confused.
is a little confusing.
It is a little
yeah.
confusing. It's a little convoluted. And then it actually says see supplement, and unless. Okay. Any?
No, nothing further.
Okay, I find probable cause for all 3 counts, and as far as the bond is concerned, I'm not inclined to disturb the convenience bonds, Mr. Afzal, unless you have something compelling.
I can tell you that, Judge, 2 years ago, he was a victim of a drunk driving accident, which he had to have multiple surgeries on his back. As a result, he applied for disability. He receives disability $733 a month. He tries to make ends meet, works side jobs. He can't afford as the bond is currently set right now. I would ask the court to at least reduce some of his bond. He's a resident of Broward County since 1979.
Mr. Linder?
I was just going to ask the court to keep the convenience bonds in place. 2006 out of Broward, strong-arm robbery. He was sentenced to 6 years state prison. He's gone to prison in the past for burglary with assault, possession of cocaine, grand theft auto, trafficking in stolen property. I'm showing out of the state of Michigan. He's had drug priors, operating while intoxicated.
He denied some Michigan charges. Never.
10. One moment, Your Honor. Does pretrial show get a hit out of Michigan for Mr. Doherty? I'm showing the same social security number. Got a year's probation for drug narcotics, 78. Operating while intoxicated from 2000. I'm also showing out of the state of Florida 10 prior failures to appear.
All right, well, I'm not gonna raise the bonds. I'm gonna leave the bonds, the convenience bonds as they're put right now. Count one, $2,500. Count two would be $1,000. Count three will be $2,500, and count three, which I cannot disturb, is $100, remains as the bond. Thank you, sir. Akil Bayanil?
Present. Good morning, Judge. How you doing, Ms. Robinson?
Do I know you?
Yes, ma'am.
Uh-huh. How long ago do I know you from?
A long time ago, like a couple months ago, like for tickets that I paid already.
Oh, okay. Oh, so you were in my courtroom.
Yes, ma'am.
Wow, you've moved up because now you're looking at a felony. That's not cool.
I know. I didn't.
All
I didn't.
Don't say anything else, sir.
Right. All right, Mr. Bayanil. Sir, you're charged with grand theft auto. Any probable cause argument?
Not based on his statement, no, Judge.
His mom is posting the bond? Oh, his bond has already been posted. All right, so I'll leave it at $1,000. You're very lucky, Mr. Bayanil, that you have a mom that's posting your bond.
Thank you. She did. I don't think she posted.
Oh,
Somebody
did.
She posted.
His bond.
Oh, I thought he said
Somebody
his mom.
posted your bond. My mom.
Well, somebody did, so you need to think that somebody.
All right, I'll see you later, Mr. Bayanil.
Thank you.
You're welcome. Barry Jones. Mr. Jones's bond has been posted? Okay, very good.
8 o'clock last night.
All right, Mr. Jones, I find probable cause for that VOP on a misdemeanor case, and I'm leaving the bond at $250 since I really can't touch it. And somebody's posted your bond, so that's good
12
news.
hours out of here.
Scott Lomagistro. Scott Lomagistro, sir, you're charged with possession of heroin. Any probable cause argument?
No, Your Honor.
What was that?
All right, I find probable cause for the charge, and I'm not inclined to disturb the bond unless Mr. Afzal, you have something compelling?
Judge, at this time, I can tell you, he can't afford any bond right now, so. And he's currently homeless, so. If the court keeps the bond as it is, we'll work on finding him a place to go.
Mr. Linder?
1 moment, Your Honor. Shown false report of commission of a crime 2012. Does pretrial have any other priors? I'm just asking that the convenience bond be kept in place, Judge.
How old are you, Mr. Lomagistro?
31 years old.
31?
Yes, Your Honor.
Wow.
Report shows at large.
I think the $1,000 is tantamount to no bond in Mr. Lomagistro's situation, but I don't know what to do. If he doesn't have an address for pretrial release to be able to.
I would just, it might be more than he says he can afford at the moment, but I think $1,000 on a third-degree felony where he apparently has no residence isn't tantamount. I would argue it's not tantamount to no bond.
He's 31 years old and he looks like he's not. Obviously, had it a little bit rough lately. So
I'm not saying he hasn't. I just don't think $1,000 bond's tantamount to no bond in light of the other circumstances.
all right, I'm gonna decrease the bond to $250.
Thank you, Your Honor.
You're very welcome, sir. Good luck to you. Matthew Sims.
Down the middle.
All right, Mr. Sims, welcome, sir.
How you doing, Your Honor?
I'm doing very well. How are you?
I'm okay.
All right, Mr. Sims, you're charged with grand theft auto. Any probable cause argument?
No, Your Honor.
All right, I find probable cause for that charge. And the bond right now is set at $1,000. It's not set. That's convenience bond. I'm not inclined to disturb that unless Mr.
Would he be eligible for pretrial?
Oh, his bond has been posted. Never mind. I'm not disturbing that bond so that you can get out. Mr. Sims, good luck to you.
You're getting out of jail. Bye.
Jonathan James.
He bonded, Judge.
Oh, wow. John Washington.
Present at the main.
Good morning, George.
Good morning, Mr. Washington. Sir, you have 6 counts. Count 1 is possession of a weapon or ammunition by a convicted felon. Count 2 is possession with intent to sell, manufacture, deliver cannabis. Count 3 is possession with intent to sell or manufacture or deliver PVP. Count 4 is possession with intent to sell, manufacture, deliver THC. The actual THC instead of the cannabis. Count 5 is possession with intent to sell, manufacture, or deliver cocaine, and count 6 is possession with intent to sell, manufacture, deliver, or deliver MDMA, also known as ecstasy. Mr. Reedy, do you have any?
I just find the probable cause very thin here as to support the allegation of possession with intent to sell. Doesn't matter to mention how many of these drugs there are, how they're packaged, how many flakka pills, how much cannabis, how many MDMA pills, how much cocaine. Without an indication here that the amount that was found is consistent with someone who would be selling it, I don't think the probable cause can be found for anything other than possession.
Mr. Linder?
Your Honor, I think for probable cause purposes, the cash, the various types of drugs, firearm, I think there's enough for probable cause, Your Honor, for possession with intent.
Well, for all we know, Judge, there are 2 MDMA pills, and there are 2 PVP pills. We don't know how much flakka. There could be a cocaine residue. We have no idea about the amounts, and just because there's cash, which we also don't know if it's connected with it because they don't mention what the denominations are.
No.
It's not cocaine residue because you can't package cocaine residue.
You can put it in a pipe.
It's not packaged. I think we can give terms for plain definition, hopefully.
Yeah, but it doesn't say if they were packaged individually for individual sale or if they were packaged all separately because you wouldn't want to mix your flakka with your cannabis, with your MDMA pills, with your PVP. I'm going to give you 24 hours to perfect on the actual delivering with intent to sell, manufacture, or deliver. That would be on counts 2, 4, 5, and 6. I, however, find probable cause for the possession of. Well, hold on, stand by on that one. Yes, they did. I see the FTP. Possession on the cannabis, THC, cocaine, and MDMA. Oh, and I find that applies to 3 as well. Possession with intent to sell or manufacture or deliver the PVP.
Hold on a second. Then, Your Honor, I'm going to ask that everything be dealt with tomorrow then. Since apparently if I can't perfect it, then I'm going to have to ask the judge. The judge's going to have to determine.
Judge for the court.
Hold on, Mr. Absal.
It's going to have to determine appropriate bonds on 2 through 6 anyway, so I would just let the judge tomorrow make the determination.
Judge, if he in essence he'll be held no bond on count 1. Will the court at least set a bond on count 1?
We're getting to count 1. As to count 1, is there probable cause argument?
I ain't worried about that. I can bond out on that.
No.
No, Your Honor.
All right, I find probable cause as to count 1. I do not find probable cause as to counts 2, 3, 4, 5, and 6. I'm not going to disturb the convenience bonds that were set on those. As to count 1, what bond are we talking about?
Judge, I would ask for a $3,500 bond. I can tell you he's a resident of Fort Lauderdale all his life. He lives with his father. He helps him with landscaping. Things are a little bit slow right now. He has no money. He doesn't have much money in the bank. Owns no property. He does have a family member that owns a car wash and a mobile detailing place in Fort Lauderdale, Florida. He would rely on him to bond him out.
Well, Your Honor, what I'm going to ask is, does the court have any objection tomorrow? Should the state perfect the other charges, that the court set this bond without prejudice? Because, an argument I would make, Your Honor, assuming that the state can perfect it, there's a difference between someone being in possession of a firearm when there's a probable cause that they're a drug dealer, as opposed to someone that's in possession of a firearm when they're just a drug user.
I would remind the state that there is, at this point in time, no probable cause that Mr. Washington is a drug dealer.
I think I said that there isn't. All I'm asking the court to do.
So what you want?
Your Honor, he has a possession of cocaine with intent to sell in '09 with a violation of probation. Your Honor, I'd be asking for a $3,500 bond on one, but again, I would be asking if the court has no objection to that it be without prejudice, and that based on any information the state provides tomorrow, the court can readdress this matter.
No. If I set it at 3,500, it's 3,500. That's a separate element, and it's separate and apart from the other ones.
Your Honor, it isn't about the legal elements, it's about the factual allegations and determining an appropriate bond. And as I stated, certainly it's more aggravating for a drug dealer to be in illegal possession of a firearm than a drug user to be in illegal possession of a firearm.
I'm not taking into account. I'm not taking into count one is possession of a weapon or ammunition by a convicted felon. The elements are whether he was a convicted felon or prior convicted felon, and another element is whether he's in possession of a weapon or ammunition. Whether he's selling or possessing, I'm not taking that into consideration. So I'm setting the bond on count one. You said 3,500, Mr. Ovzal. That's right. Yeah.
Yes.
Yeah, I'm gonna set it at 3,500, and counts 2 through 6. You guys will be back here tomorrow for 24 hours. It's perfect. All right, Jerome Parkinson.
Paul Ryan.
Okay. How are you, Mr. Parkinson?
Good morning.
Your Honor, he was arraigned yesterday. Bond was originally set on one of the sex crimes at $10,000. We added charged another one. Just asking that they both be set at $10,000.
But there's 2 more that are being added.
That's what, Your Honor. One was a change of charge and one was added.
He was arraigned yesterday. The bond was set yesterday at 7,500.
Okay, then
3 and 4. Is that what you're presenting?
I think so. So
Yeah,
that's
we're
fine.
here from 3 and
7,500.
4.
Fine. Perfect.
I've spoken with Mr. Parkinson's public defender, Vivian Garibaldi. She's aware of the situation, so she'll be addressing that, I think, in front of the division judge.
All right, so I'll set 3 and 4 were set at $7,500, madam.
Yes, as of yesterday.
Each.
7,500 each.
Okay.
Do this guy.
I find probable causes to both charges. Sir, you're charged with count.
Would waive formal reading of the charges.
I'll waive reading. Yes, you're right. I'll waive formal reading of those, and then on count 3, I'll leave it.
We're only here for count 3 and 4, right, Your Honor?
Yes, that's all I have in front of me. I'll leave it where it was yesterday at 7,500. Thank you, sir. Good luck to you.
Thank you.
All right. So with that, we're off the record.
We have one more case.
You have one more case? I don't have anything.
Perfection.
Robert Hearing in North Broward, Judge.
Okay. Mr. Robert Hearing in North Broward.
No, that's him.
Judge Solomon didn't have any additional paperwork. I've provided that to the court at this time.
Can we be more specific? Because frankly, from 2 days ago, I forgot exactly what we were perfecting on this case.
You said Judge Solomon didn't have any additional paperwork. There was no paperwork attached, so I...
No paperwork.
Yeah.
Judge Solomon? Oh, so you're giving me the PC affidavit now?
That's what I'm... Yes, Your Honor.
Oh, okay.
That was a supplemental report. This is a filed case. It's an ad charge. That supplemental report was provided by the arresting officer.
This is on a capias.
Your Honor, all I can do, I have to respond to Judge Solomon's ruling. She said she didn't have any paperwork, so she was finding no PC, so I'm providing the probable cause affidavit that covers the charge.
Okay. Well, I find probable cause on that capias that was originally signed by, I believe, Judge Cora.
What's the charge?
It is, sir, very good question. No, Judge Cora signed 4 and forging, having, I guess, possession of a forged or counterfeit credit card. And that bond that was originally set by Judge Cora is at $1,000. So I can't disturb that bond on that warrant. All right, Mr. Hearing?
All right.
Take care, sir. Good luck to you.
Okay, hey, here's.
All right, so with that, we're off the record. Thank you very much. We'll be back at 1:30.